All the list.
That may be permitted to mention item number 103, last item of the today's list. Urgency is this, we have challenged the corrigendum of the recruitment notice. On the basis of written test has already been held. Interview started from 9th January, has already been started. We have challenged the recruitment notice. Kindly fix any date.
Sorry. Yes. Any other mentioning? Yes. Release for what? Which matter?
Look, yesterday I mentioned the matter has been tagged together in respect of 10% vacancy. Lordship has made it part that upper primary for academic credential upgrade. But,
Sorry. Yes. Please call the list.
matter has been
Enough is enough. Please call the list. Sorry. Sir, assigned matter, you are seeking release. Yes, please call the list. Item number matter was hard on number of occasions. Sorry.
Lord, in respect to 10%,
Yes,
it
yes.
was heard, my lord. It is 90%.
Please call the list. Call the matter from the list. Yes. Item number 1.
Well, I appear for the respondent. Your Lordship, direct the last occasion regarding that report which was prepared and handing over today.
I appear for the state lord.
At the time of assignment, you could have approached the Secretariat of the Chief Justice that this is not matter coming under the same head. And not only this, prior to that, when I had the determination, I heard the matter at least on 5-6 occasions.
My lord, the seniors were submitting.
So, yes,
the-
yes, and now when the all the matters are assigned, even after change of determination on the prayer of the learned advocates, you are embarrassing this court. Please don't do this. You are a junior member of this court, of the bar. Please don't do this. And who is senior, tell him to come to before me and mention.
I apologize. I apologize. I sincerely apologize.
Why you did not mention when I heard the matter at least on 5 occasions when I had the regular determination that this is not a matter coming under this particular head? And thereafter, I did not make those matters hard in part. Then learned advocates approached the Secretary of Chief Justice for assigning this matter to this court.
But the
Why you did not wrote a letter to the Secretary of the Chief Justice?
I wanted to mention.
Before mentioning, please think over it.
I apologize, my lord.
You should not have mentioned this matter. You had the opportunity before me when I was taking up having the regular determination of Group 2. It was not pointed out before me. I have nothing personal so far that your matter is concerned. Then I did not, even after hearing those group of matters for 5-6 occasions, I did not make those matters hard in part. Then the learned advocates appearing in those matters approached the Secretariat of the Chief Justice, and then matters have been assigned to me. And now you are mentioning before me after assignment. Tell your senior to mention before me. Yes, yes, Mr. Ghosh.
Well, I am submitting the report as Your Lordship directed on the last occasion.
You are a junior member of the bar and you have to be here for a pretty long period of time. So before mentioning, think over it what you are mentioning. After assignment, you are mentioning this matter for release. What is going on? And you will not think twice before mentioning this matter. Everything can be mentioned. And this is not the first occasion I have taken up this matter.
Yesterday I mentioned because of urgency.
Unfortunate situation. You should have thought over it twice. Others will not come, seniors will not come and send a junior member, go and mention. We know all these tactics. I'm really sorry to say all these things. Who is happening for the petitioner?
Lordship, on the last occasion, I appeared for the state lordship. On the last occasion.
Yes, last occasion petitioner was not represented.
And we were directed to inform them. We have sent them a mail, and thereafter, my learned brother, has also informed the petitioner's advocate via WhatsApp. Not represented today also, but I believe he was informed via WhatsApp that she or he has recused himself or herself from this matter. However, we advise them to come and inform the court accordingly, but I find that they have not appeared.
Your report, Mr. Ghosh.
But just now I'm handing over to
How do you get the mail of that learned advocate representing the petitioner?
From the brief, my lord, from the back sheet, the email of the advocate on record was there.
We could not serve the hard copy of your notice.
My lord, I tried. My clerk could not find him, so I emailed my lord. And my lord, yesterday evening, he WhatsApped me. He received the mail. He WhatsApped
What is
me
the
that
name of that advocate to whom you have
Mr. Safdar Azam.
Safdar Azam? Issue. Mr. Alok Kumar Ghosh, learned advocate representing Kolkata Municipal Corporation, has filed a report in the form of affidavit which was affirmed on 7th November 2025, and same is taken on it. Next paragraph. However, petitioner is not represented by learned advocate today. Stop. Same situation prevailed on 6 January 2026. Stop. On 6 January 2026, by passing an order, court directed learned advocate representing state respondents to serve notice upon the learned advocate representing petitioner by 9th January 2026. Stop. Next paragraph. Today, learned advocate representing the petitioner has submitted a notice by email letter dated. State respondents has submitted a notice by email letter dated 7 January 2026. 7 January 2026 was sent or was forwarded to the learned advocate representing the petition, and copy of email letter dated 7 January 2026 is placed before this court and same is taken on record. Next paragraph. It appears petitioner has lost interest. Stop. Writ petition stands dismissed. Parties to act on the server copy.
No, but after the filing of my report in details, he said relating to birth certificate for issuance, is an attempt to take the birth certificate by an order of the court in different manner. I had to lot of exercise.
And thereafter this report was
I
prepared.
collected the birth register from the maternity home also. And that all these papers and documents have been arranged. I knew that he will not come further before us.
Whether the report was served upon
Yes, yes. And that is the reason why
so everything is disclosed in the report. Now, what is the actual state of affairs?
actually no birth certificate was no birth was taken place of that lady in that particular maternity home. There's a lot of cases, like criminal case and all the other.
Yes, that I remember.
The birth certificate was requiring
Criminal case is pending, that was recorded probably in my first order.
Great.
Item number 2.
Please, your lordship. Because in this matter, I have checked that it is a matter of the cat. I have checked it. Yesterday, well, can you give me the liberty so that I can
Yes.
move it before
Because a railway employee,
railway employees? It's a mutual transfer.
you need to approach the Central Administrative Tribunal, CAT.
Yes,
Issue.
the liberty may be given.
Yes, yes. Learned advocate representing the petitioner appears on virtual mode and submits that inadvertently writ petition was filed. Though petitioner though the issue involved in this writ petition relates to service under Eastern Railways or under Railways. Stop. Next paragraph. Union of India is represented by learned advocate. Next paragraph. In view of aforesaid submission, writ petition is found to be not maintainable before this court at this stage, and same stands dismissed. Next paragraph. However, this order shall not preclude the petitioner to approach Central Administrative Tribunal on the self-same cause of action.
Yes.
Parties to act on the server copy. This
I'm
order.
grateful. I'm grateful.
Item number 3.
Item number 3, my lord, I beg to appear on behalf of the petitioner. Ask petition, your lord.
Where is Mr. Trivedi?
My lord, he is on his way, my lord.
And an unqualified apology for yesterday, Millet. I was in personal.
Yes.
Just आपको copy, आपको copy.
Millet, as far as this case is concerned, Millet, Lordship had it has fallen from my lord that panel system, whether it is there. No? So my lord wanted me to assist your lordship as far as that is concerned, lordship. Lordship, this is our instructions, Millet, and we have also annexed, Millet. Millet, we have clearly stated it, Millet. In paragraph 2, 3, 4, and 5, Lordship, what is the
Procedure followed.
Lordship?
Just. MH is Ministry of Home Affairs.
Lordships. काम होता वाला हमारे तो ब्रीफ ही है ना.
ये दो जजमेंट जी है कोर्ट बेंच है. जजमेंट जी है कोर्ट बेंच है.
जी दिखाएंगे अगर जरूरत पड़े तो. बाद में देख लें. पढ़ा हुआ है सर वो पहले भी इसके ऊपर वो जजमेंट देखा हुआ है सर. पिक्चर अभी तो साफ बोल रहे थे.
So it is submitted, it is reported, this report that there is no concept of maintaining a panel or wait list for a particular period of 1 year. When the vacancies are there, in 13 December 2024, constable GD examination had already been declared. Final result was declared on 13 December 2024, based on which appointments were made and what are the vacancies which are available that are carried forward to the next selection process of 2025.
Yes.
So therefore, normally in a selection process, it is found that a wait list or a panel is prepared and which remains valid for a period of 1 year. Here, there is no such system. Once selection is made, final result is published after detailed medical examination and completion of from the list. Appointments are made, and thereafter, if any unfilled seats are there, these are carried forward. Now, in this writ petition, petitioner participated in 2024 selection process, and writ petition was filed on 1st February 2025. 1st February 2025, when the entire selection process is over, because final result was published on 13 December 2024. So after that, what remains?
Lordship, the specific query before your Lordship, which fell from your Lordship in order dated December 10, was the lifetime of the panel. Now, what the report says, what I can gather is that with regard to the board, the medical board and the executive board, which is created for the purpose of selecting or for processing the medical tests, that is over immediately. Whatever the time frame is there, when that is completed, that is dissolved. That is all right. But your Lordship will find, even from the guidelines of the 2024 recruitment, it specifically it says that a period of 1 year is there, within which time, if a candidate who has been selected, if he is not favored with a recommendation or an appointment letter, he may approach. So it is not that immediately it is dissolved and the entire recruitment process, all the vacancies get dissolved and they are forwarded.
Where is that
Yes.
provision in the recruitment
Yes,
rules?
this is 26. This is
Which page?
this is courts.
It is noticed dated 24th November 2023.
24th November 2023, your Lordship. This is under 20, column number
20.
Column number 20, this is page 27, internal page 27 of page 56. No, probably not in the repetition, your Lordship. Your Lordship,
No, not in the writ petition. I am reading this.
Yes, page
Yes.
27, internal page 27. This is serial number 26. The last, your Lordship will find.
26, just a minute.
Yes, should kindly see.
But it does not say that the panel remains valid. It says
Until and
even if
unless
a
this
candidate is finally selected, but he does not receive any correspondence from the commission or the concerned user department within a period of 1 year after declaration result, he must communicate immediately.
Yes.
Here you are not a selected candidate.
Maybe
You
not.
participated in the selection process, but you are not selected. Now, and the writ
So they
petition
will
was
be acting on the basis of that panel for within a period of 1
writ
year.
petition was filed on 1st February 2025 when the entire process is over.
But
Because
I
the
say
because the
Lord, may I-
result was published on 13 December 2024.
May I assist only on one point?
Yes.
That will create. My lord will kindly take page 3 of this.
Of
Of this notification, which is my lord, before my lord, page 3, lordship. Lordship has got page 3.
just a minute.
Pagination at the bottom, my lord.
Just a minute.
This particular portion of the notification also forms part of the petition. And my lord, the entire compilation. Page 3, my lord, of the notification. Lordship has got it?
Yes, page 3.
3.6, my lord will kindly take into consideration. May I read for my satisfaction? The commission shall not prepare or maintain waiting list, reserve list after the declaration of final results.
So from the result, a list is prepared and selected candidate, and that is exhausted.
Vis-a-vis what my learned friend is trying to impress upon my lord, this is a where a person has been selected. Maybe he
But it does not. That is what
maybe because he remains in a remote
that
place.
is what I am telling you. The
Correspondence to-
person is selected. His name is in the select list, but he does not get a call letter.
Because of any reason, extraordinary reason, if he reports.
An unsuccessful candidate is coming in February 2025, and today we are in the month of February 2026, when the new selection process has already begun in 2025. The date is also there. So far, the subsequent selection process is concerned, and you are you are praying for consideration of your candidature in connection with the selection process of 2024.
Lordship, I have specific instruction that till date there are appointments which are being granted after re-verification of after reconducting of medical tests. Some persons who have
In
been declared fit-
2025 examination, when the final result is published?
My lord, 2025 examination must have published because the year is together.
Not published. Not published.
Not published. No, my lord, it has not been published.
Not published. It's going on.
My lord, my simple submission before my lord is that, my lord, as far as the notification is concerned,
PST, PAT and DME city has been also concluded. Final result declared by staff selection commission 13 December 2023. Yes. Already what has happened here, since there is no panel prepared, which is kept valid for a period of 1 year, which is the normal usual system. Here, unfilled vacancies of constable GD for relating to recruitment process of 2024 were carried forward for the next recruitment of constable GD, and it has merged with the pool of vacancies of 2025 selection
I
process.
say not
And
because
where
with regard to court cases.
where already the examination, that is physical standard test, physical endurance tests, then the medical test, all are over.
I say that with regard to 2024 selection process, where court proceedings are pending, and where petitioners have been favored with a re-examination, that has been done, and appointments are still being granted. So that is
No,
always.
while delegation will not do, you have to show me.
No, I have to take instruction.
You have to show me. While delegation will not do.
I'm
Have you
just
made
saying-
out a case in the writ petition that
yes, sir.
Mr. X has been appointed
Yes, sir.
from 2024
That is
panel
being done. If your
or
lordship-
in connection with 2024 selection process?
Lordship, at that point of time, probably the.
And you show me that there is a system of maintaining a panel for a period of 1 year. Then I can understand. Show me from the recruitment.
From 26 of
Apart from clause 26, there is nothing, and clause 26 does not say that maintaining the panel for a period of 1 year.
unless that is maintained, your lordship, a
Esho.
selected candidate cannot. Your lordship
Sorry.
kindly grants me some time.
No
to-
further ground time, sorry.
Lordship kindly consider-
Matter is heard in presence of the learned
Lordship,
advocate
your lordship,
representing the petitioner and Union of India. Stop. Next paragraph, Mr. Dhiraj Trivedi, next paragraph, Mr. Dhiraj Trivedi, learned Deputy Solicitor General, has placed before this court a report dated 8 January 2026, signed on behalf of IGP WBS CRPF Kolkata, and same is taken on record. Stop. Next paragraph. Based on such a report dated 8 January 2026, a copy is given to them.
My lord, I've given.
A copy of the report is made over. A copy of the report dated 8 January 2026 is made over to the learned advocate representing the petitioner. Next paragraph. From the next paragraph, it is submitted on behalf of Union of India on placing reliance upon the report dated 8 January 2026 that there is no provision for filling up the post of Constable GD under Central Armed Police Forces within bracket for short CAPFS to keep a panel of selected candidates alive for a period of 1 year after
Lordship, this is an affidavit.
After
of March
the-
2025.
after the selection is over. After the selection is over. Stop.
Lordship kindly allows me.
Stop. It is also disclosed in the report that selection process for the year 2024 was complete on 13 December 2024 on publication of final result.
Your lordship-
Stop.
your lordship,
After publication of final result, candidates who were selected were given appointment. Stop. Unfilled seats were carried forward to the next selection process, that is 2025, that is selection process of 2025. Stop. It is further disclosed.
Your lordship, the
Dissolved.
authority says that there are vacancies in March 2025 and says that they will be granted appointment if the candidates are declared fit. Your lordship kindly sees this.
Which affidavit you will like? Which affidavit? Another matter, which matter you are taking out things from pocket and you are saying, why you are making such a submission?
Your lordship kindly grants me some time so that I can bring this.
Please, I have heard this matter on number of. Please don't disturb this court. I don't like this. I have heard you on number of occasions. Sorry.
Your lordship,
Yes.
one thing, there is an affidavit of March 2025 where the union says that there is a vacancy of 845 candidates and who will be granted appointment if they are declared fit.
Which matter?
With regard to 2024 recruitment process.
Which matter? Is it a part of?
27456 of 2024.
হ্যাঁ কি বলছিলাম? Unfilled seats were duly carried forward. It is further disclosed to Kedera. Stop. Therefore, according to the respondents, there is no scope left open to appoint a candidate in connection with the previous selection process of 2024, wherein result was declared on 13 December 2024. Stop. Next paragraph, learned advocate representing the petitioner has placed reliance on clause 26
Serial
of the
number?
notice dated 24th November 2023 relating to selection of Constable GD under CAPFS and Rifleman within bracket GD in Assam Rifles examination, wherein it is provided that if a candidate is finally selected and does not receive any correspondence from the commission or the concerned user department within a period of 1 year after declaration of result, said candidate is required to communicate immediately to the concerned department. Stop. Based on clause 26, it is submitted that still selection process of 2024 is alive and candidature of the you are not a selected candidate. Candidature of the and petitioner's candidature needs to be considered in connection with said 2024 selection process. Next paragraph.
Chief kindly adds that by submission that in another matter the union has
The report dated 8 January 2026 is found to be pertinent, wherefrom it is found that Ministry of Home Affairs, now wherefrom it is found that as per rules and notice of Ministry of Home Affairs and Staff Selection Commission, there is no provision for preparation and maintaining of waiting list or reserved list of candidates in the particular candidates in respect of particular recruitment process. After recruitment process, stop. After declaration of the after declaration of stop. After declaration to the stop. Final result for recruitment in the post of Constable GD for the year 2024 was published by Staff Selection Commission within bracket SSC on 13 December 2024, and all unfilled vacancies of Constable GD were declared, and after recruitment all unfilled vacancies of constable within bracket GD relating to 2024 selection process were carried forward to the next recruitment process of 2025. Stop. It is also submitted, it is also indicated in the report that physical standard test / physical efficiency test, comma, detailed medical examination have also been concluded in connection with 2025 selection process. Stop. According to the respondents, no vacancy for the selection process of 2024 exists, nor any waiting list is maintained till date. Stop. As per the said report, existing rules or relevant rules and scheme of Ministry of Home Affairs Executive Board and Medical Board are constituted only for the particular center and only for the forest and only the কেটে দাও and for a specific period. Stop. After completion of a recruitment process at the center, at the said center, such recruitment board are dissolved immediately. Semicolon. Validity of such board is restricted to the particular recruitment process and
वाला कार्ड खेल गया
particular recruitment process which is confined to a specific center. Stop. Next paragraph. It is further disclosed in the report that list of selected candidates is prepared strictly in accordance with the number of vacancies duly allotted created, and no candidate in excess of the notified vacancies is included in the merit list. Unfilled seats after recruitment are carried forward to the next year selection, to the selection process of next year. Next paragraph. On the contrary, clause 26 of the notice dated 24th November 2023 does not come in aid of the petitioner. As said clause provides, in the event a selected candidate does not receive correspondence from the commission for his / her appointment, in that event said candidate is required to approach the concerned department immediately. So in the instant case, petitioner is not a selected candidate. He participated in 2024 selection process. in connection with which final result was published on 13 December 2024. Therefore, it transpires that entire selection process by recruiting candidates on publication of final result was over after publication of result. Stop. As there is no system of maintaining a panel for a period of 1 year. Present, no relief can be granted in the present writ petition, which was filed on 1st February 2025. Stop. Or no relief can be granted in the present writ petition. Stop. Next question. Hence, writ petition stands dismissed. Urgent. Next.
I'm grateful, Lordship.
যেটুকু করে দাও।
Okay, that's the copy.
Item number 4. Do you want to file an exception to this report?
Yes.
I'm not satisfied with this is your report you are filing, Mr. Trivedi, today.
My lord, affidavit, my lord, report we had filed, my lord. Lordship will kindly recapitulate. My lord had more or less taken into consideration all the aspects. Then my lord wanted me to come on an affidavit because there were certain factual aspects which needed to be affirmed on affidavit. This is with regard to, my lord, selection of honorable judicial officers, adjudicating officer of the railway tribunal, who are selected amongst the ex-judicial officers, learned advocates. Now, my lord, here the staff service commission, search and selection committee, which is acting under the aegis of the Honorable Chief Justice of India, decides the entire process. The interview is conducted. Now, my lord, here the preliminary point was that railway has been made a party. Railway is not a party concerned with regard to selection of adjudicating officers to railway tribunals. It is the selection and search committee, which they have also admitted in their writ petition. One. Secondly, Lordship, this was a pan-India selection. So, my lord, this honorable court did not have the jurisdiction. That was the initial preliminary point which was taken by this honorable court. Now, my lord, on consideration of other aspects on merit also, my lord was pleased to direct me to file an affidavit. Now, my lord, I have filed it. So these are the preliminary points. Now, if my lord intends, my lord, if it falls, my lord, that they want to use a reply, my lord, I will not stand in the way because I'm my lord's officer. But my lord, that is what is all about, my lord. This.
So for the we are taking the preliminary point of maintainability of
lord,
petition on jurisdictional point.
Jurisdictional as well.
According to you, where this writ petition, the issue is need to be considered.
My
by
lord.
Which authority?
My lord, authority, my lord.
By which forum?
My lord, we have twofold submissions. One, my lord, if my lord kindly takes up the writ petition for my satisfaction. If lordship takes up page 3, paragraph 4
of the writ petition,
lordship, my lord, they themselves has categorically stated that it is the, my lord, search cum selection committee which is responsible for these appointments. Now, my lord,
yes, if it is an issue relating to the exercise made by search cum selection
lordship,
committee,
they are not even parties. They have not even parties. One, my lord. Secondly, if my lord kindly takes up my affidavit, my lord, which whatever we have stated, my lord, we have stated, my lord, that what is the process? It is, my lord, the search cum selection committee which calls for these candidates. They are shortlisted. Initially, Millard, there were 92 candidates were there who were out of when 71 were selected. IB report was followed, interview was, and then Millard, there were 16 candidates. Now, Millard, this is the process which has been followed by the search cum selection committee. And under the aegis of the Honorable Chief Justice of India, we have nothing to do. My Lord knows, Millard, how tribunals, and be it NCLT, be it DRT, or be it Railway Tribunal, they are all working under the aegis of the Honorable Supreme Court. So, Millard, we, as far as the selection of those adjudicating officers are concerned, Millard, we can at the best enlighten my Lord or usher my Lord's path to the facts and circumstances. But, Millard, we are not the right authority to place a challenge on that we were responsible for non-selection of the gentleman. Now, Millard, so Millard, even if my affidavit is taken into consideration, though I have various other points which are very strong, but Millard, this is primarily, Millard, I am asking a question to myself, Millard, until unless search and selection committee, which they themselves have stated that those were
The entire selection was made by surgeons.
Millard,
search
that
and
is the
selection
process.
committee.
That is the process, Millard. Because my Lord knows, Millard, I am a party to any adjudication before the tribunal. Now, if I select my own honorable judges in the tribunal, that cannot be the process of law. Process is different, my Lord. I mean, I can show the law, my Lord, and my Lord knows, my Lord. Because, my Lord, I have also stated in my affidavit, if my Lord kindly sees, my Lord will kindly see page 2, last paragraph of my affidavit.
Affirmed on 21st January.
Lordship. Today,
Page
which we have
eight.
handed over. My Lord, page 2, last paragraph, my Lord. That a vacancy circular dated 18/9/2021 was advertised for 2 posts of vice chairman, 2 posts of vice chairman technical, 16 posts of judicial members, and 7 posts of technical members of RCT, that is Railway Claim Tribunal. For vacancies on 31/12/2021. For this purpose, a search cum selection committee was constituted as per the provisions of the Tribunals Reforms Act 2021 under the chairmanship of the Honorable Mr. Justice B.R. Gawai, Judge Supreme Court, Chairman, RCT Secretary, Department of Legal Affairs, and Department Secretary, Department of Consumer Affairs, were made members of the SCSC, that means Search and cum Selection Committee. Operator, that the SCSC held a preliminary meeting on 22/3/2022, wherein the committee shortlisted candidates at initial level and decided the documents for obtaining IB report police verification may sought for these candidates only. That thereafter, on receiving IB reports from Ministry of Home Affairs, the SCSC held its second meeting on 14/9/2022, in which
Yes, in which it was
may
decided.
I read it? I apologize. Yes. According to the SCSC, held various interaction with post of judicial members on 11/10/2022 and 12/10/2022. That keeping in view of the Tribunals Reforms Act 2021 and Tribunals Condition of Service Rules 2021, the SCSC, through personal interaction, after taking into account of suitability, past records of past performance, integrity, as well as adjudicatory experience, keeping in view the requirement of the tribunal, recommended 32 candidates only against 16 posts of judicial members. That the committee again held a meeting on 7/2/2023 and decided to exclude 4 recommended candidates for earlier panel of 32 candidates in view of the adverse feedback received against those 4 candidates on final recommended names of 28 candidates. That the name of Sri Shovan Siddhanto was not recommended by the SCSC in the panel of 32 candidates. Similar, there was 1 candidature, then 92 he was there, then in 32 who was not there. He did not challenge that. Now, Millard will kindly see, last but not the least, Millard, the penultimate paragraph, my Lord, will kindly see of that page, page 4, that it is also mentioned that the Ministry of Railway has no role in deciding selection appointment of members of RCT. The names were recommended by SCSC constituted under the chairmanship of the Honorable Sitting Judge of the Supreme Court, and finally the appointments were made with the approval of the Appointments Committee of the Cabinet. So, my lord, here, my lord, and my lord will
So why SCSC has not been made party? Because entire selection was made by the SCSC. What railway authority will do?
the act itself says, my lord, what is the which we have said.
First of all, my lord, they given reply purportedly to my representation.
Because as it appears from the statements made in paragraph 3 of the report, that the
And my lord,
entire
this writ
exercise
was in
made by
2025.
a search and selection committee.
And my lord, writ is
Search
filed in
and selection committee.
my lord, writ is filed in 2025. Process is of 2022.
Let me submit for my lord,
My lord will see that also. I was saying, my lord, there are many other points apart from jurisdiction.
my lord, this is very much irregularity in the appointment process. I have challenged that. There is no provision that there is third shortlist will be published. Third shortlist, 1, 2, and 3. No provision in the appointment. Appointment was
But this was done by which authority?
according to the search and selection committee.
Not me, according to them, page paragraph 3.
For them, if my learned friend can furnish their address, I do not know whether it is a permanent body or not. Only the taking name of the then Chief Justice, my lord, I cannot point out their irregularity if any.
And that selection was made in far back in 2023.
No, my lord.
My lord, it is there on affidavit.
The
we have
next
said.
petition is of 2025.
It was shortlisted.
Where will you file an exception?
My lord, let them file it.
Let him file an exception.
And
The
my
matter
lord,
has to
my
be
lord,
decided finally.
my lord, let them file. I'm not standing.
Provide me the address and search and selection committee.
Not at this stage, sorry.
No, my lord.
No, no,
I
no.
was, my lord, I was
No.
praying before your lordship.
No,
in
no.
Earlier occasion. Otherwise, my lord, how can
Sorry,
this matter be
sorry,
adjudicated?
not at this stage.
Kindly, my lord.
In terms of the previous order,
Kindly give that liberty, my lord. Otherwise, it cannot be adjudicated properly. Search and selection committee is not above the law.
a report in the form of affidavit affirmed on 2nd January to 2026
And copy was served on 7th of January.
My lord, another point, my lord. I will
is filed
point out.
today and same is taken on record.
I will point out one very vital point, my lord.
Stop. Learned advocate representing the petitioner has prayed for opportunity to file an exception to this report.
Well, it
Stop.
is an affidavit.
Let an-
My lord. Let them file affidavit and reply.
Let an affidavit taking exception to this report be filed
I'm
by
grateful.
fortnight from date.
I'm
Stop. List the matter under the same heading for further consideration on.
পাঁচ মিনিটে হয়েছে না
10th February 2026.
I'm grateful.
The only thing I will point out. They have today.
You will point out after you file your exception. Please don't waste court's time in today.
My lord's leave.
Search and selection committee, my lord, will be out of this.
Item number 5.
I am appearing on behalf of
Union of India.
Yes.
This matter, your lordship, they have asked for an ex gratia payment. My lord, there is a circular. My lord, my junior will hand over that
You
circular
are
to your
representing
lordship.
Mr. Jha. You are representing whom? Union of India.
yes, my
Union of India. Union of India.
Yes. Union of
India.
India.
Yes, my
চিরন্তন সরকার
This is related to
Just.
payment of ex gratia.
Justin. Yes. So which government order will apply?
My lord, this is the report, my lord.
Yes. What does it say?
My
And
lord,
X.
What does it say?
My lord, this is a circular, my lord, where they say
You
that,
have
my
paid
lord, for
5,000
permanent,
rupees for bulletin,
my
for
lord.
receiving bullet injury, 5,000.
My lord, this is the circular which was existing at that point of time, my lord. We obtained that, my lord. That is comes to there where it is
For
mentioned, my
winning a
lord,
tournament, how
10,000.
much you pay?
My lord, I have to, my lord, kindly pardon me, my lord. But this is the thing which
For
will
winning a
not, the
cricket match,
circular
how
which
much you
goes
pay?
to say this, my lord.
For receiving bullet injury, 5,000.
My
And that too in 2025. When this was
lord,
paid?
90.
1992, injury was received in
my
1992.
lord, this injury
And
was
when this ex gratia was paid?
1992, my lord.
And that point of time,
It's immediately.
It was paid.
admitted in the hospital.
But it was paid. 5,000 was paid.
5,000 was paid, but whether it is
It
in
was
order
paid, my
for
lord, that.
medical expenses, that was
No, they submitted that 5,000 was towards ex gratia.
That is, if that is, then 70,000 is due. 70,000 is due. My lord, may kindly see
B, my lord, page 2.
Page 2.
Page
from
2.
there.
B, my lord.
B.
Yes, my lord.
Page
Personal
2B.
for-
Just a minute.
Really.
Yes, which part you are relying upon? First of all, it is not readable. Which part you are relying upon?
Page 2, my lord.
Yes.
B, my lord, personnel for paramilitary force, my lord. B, for
B. What it starts with the which sentence?
it is, my lord, column wise, my lord. My internal page 2, my lord. Internal page 2. Title, my lord, starts capital B, personnel for paramilitary force, my lord. My lord, kindly that.
Yes, personnel for paramilitary forces. For death, for. Is a case of permanent disability.
Yes, my.
So 0.75 lakh. What is the date of this notification?
My lord, 10/7/1990, my lord.
Where from you are getting this?
My internet page 1, report page 2, my lord. Just earlier page, my lord.
10/7/1990.
Yes, my lord.
10/7/1990. At the top, at the middle.
At the
Page
top,
1.
Page 1, my lord.
Yes, if that is the circular or that is the order dated 10 July 1990, that for permanent injury, the member of the force who suffered such injury is entitled to get 0.75 lakh. Unmute yourself, Mr. Jha. Unmute yourself.
I'm
Yes.
extremely sorry, ma'am. My lord, so
Yes.
far, my lord will kindly come to page 13, my lord, of the writ petition, my lord. That is the medical certificate, page 13, my lord.
Page
My lord,
30.
page 13, 1-3, my lord.
1-3.
Annexure 2.
Yes.
This is the medical certificate, my lord. So far, my instruction goes, my lord, he has not this injury which was suffered by him. Nowhere description of disability, my lord. It's not permanent disability. They are saying, my lord. Kindly see the left hand side portion corner, last one, my lord. Description of disability.
Just a minute. Yes, I mean. No, it is said as per report, she has been found to be orthopedically disabled with complete disability of permanent nature, assessed at 100%.
Thereafter, my lord. Thereafter, my lord.
Thereafter, it is written
Description
a
of disability,
description of disability,
traumatic paraplegia.
my lord. So far, so with regard to that,
Description of disability.
so far,
But it said that disabled with complete, orthopedically disabled with complete disability of permanent nature, assessed at 100%. Page 13.
13, my lord. It's saying that, my lord.
So it's a
It says
100%
so.
disability, complete disability.
My lord, my
So
lord.
if it is a case of complete disability, then petitioner is entitled to get 0.75 lakh. Why 5,000?
Page 14 is also, my lord, there. That is the medical board of BSF's, my lord, report. That also says it is 100% permanent disability. At paragraph 8 and 9.
Yes, Mr. Jha.
My lord, my lord.
If it is
My
a
lord,
case of
my
complete
lord, my
disability,
lord. I bow down to your lordship, my lord. It has to be 0.75, subject to my lord. Yes, my lord will record my formal objection, my lord. So far the circular goes, it has to be, my lord, 0.75.
how this 5,000 was paid?
5,000 was, my lord, paid as I am being instructed to the hospital by the authority.
So whether this is to be adjusted or he is entitled to get the entire
My
0.75.
instruction is not he is entitled to get the entire money because
What is your instruction to that extent, Mr. Jha?
That instinct I need to take instruction, but so far my understanding goes, my lord, that needs to be adjusted, my lord.
kindly consider BSF is an authority. They would not pay in half or in a meager amount. Either they would pay everything or nothing. So 5,000 was something else.
He was in Kashmir.
If your lordship kindly grants me time for one day, my lord, I'll take the instructions to that effect also, and I may come back, my lord, before your lordship, my lord.
Issue. Petitioner, by presenting this writ petition, inter alia, has prayed for payment of ex gratia as the petitioner being member of BSF, being member of Border Security Force, received bullet injury or received না করে suffered bullet injury. Stop. Petition at the material point of time, petitioner was posted in Kashmir. Stop. Reliance is placed on what is the date of this medical certificate, page 13?
Seven, 12,
97 more.
97.
97.
97. Reliance is placed on a certificate issued by Civil Surgeon Jalandhar, dated 7 December 1997. Stop. According to the petitioner, he was permanently disabled due to bullet injury he suffered, which makes him entitled to receive ₹0.75 lakh towards ex gratia. Stop. Next paragraph, Mr. Jha, Mr. Brojesh Jha, learned advocate, representing Union of India, appears on virtual mode and has submitted and has opposed the prayer of the petitioner. Stop. It is submitted already. Rupees 5,000 was paid to the petitioner for his treatment just after the incident, wherein petitioner got injured. Stop. It is further submitted that whatever was payable to the petitioner for suffering bullet injury was paid to the extent of rupees 5,000, and no further amount is payable to the petitioner. Stop. Next paragraph. Petitioner was serving in BSF and retired on superannuation on 30th November 2025. Stop. According to the petitioner, till date ex gratia amount or till date ex gratia which was payable to the petitioner in terms of relevant order remains unpaid. A government order is placed before this court dated 10 July 1990 relating to payment of ex gratia relief for being permanently or partially disabled as a result of violence attributable to the breach of law and order or any other form of civil commotion. Stop. Member of BSF who were killed are also entitled to get ex gratia as per said order dated 10 July 1990. Stop. Clause capital B within bracket clearly provides for permanent disability, a member of BSF is entitled to receive 0.75 lakh. Stop. In the present case, medical certificate in the present case certificate dated 7 December 1997 issued by civil surgeon Jalandhar discloses the petitioner become permanently disabled and petitioner became permanently disabled to the extent of permanently disabled within bracket 100%, and nature of disability was traumatic paraplegia. Page 13 page है traumatic paraplegia. Stop. Next point. Therefore, it appears that in terms of the order dated aforesaid order dated 10 July 1990, petitioner is entitled to receive 0.75 lakh towards ex gratia. Stop. Next paragraph. Hence, concerned respondent authorities are directed who is to make payment.
My lord.
That is, my lord, is Inspector General, BSF Frontier Headquarters. That is respondent number.
Achha, hence, concerned authority of Border Security Force is directed to release 0.75 lakh to the petitioner by 4 weeks from the date of communication of this order. Stop. Along with 6% interest from the date the amount became payable to the petitioner till the date of payment. Stop. The writ petition stands disposed of. Ajay Xerox.
Extremely grateful.
Item number 6.
Require me to give a supplementary affidavit showing the last page drawn by at the rate of 60,400.
Just
Paragraph 2A, my lord.
yes, where is the payslip?
Yes, I have annexed. It's number 4, 4, 5, and 6. These are my lord three payslip.
Show me the last payslip
Last-
when petitioner retired 31st of July.
Yes.
Payslip for the month of July, is it page 4.
July 2020.
Where is the basic pay in the state indicated?
Basic pay at the left hand side, my lord, 3, the third. Basic pay 60,400.
But pension was paid to
At-
you based on the basic pay of rupees 58,600.
Yes, 600.
That is your grievance.
Yes, that is my grievance.
Yes.
And not only that, my lord, recently, my lord, I have been issued, my lord, the pensioner's identity card. There also they accepted that my last pay drawn is, my lord, 60,400. I have the copy with me.
Yes.
Recently it was
Why pension was paid considering
But I have
wrong
not
basic
received
pay?
any instruction. Only what I found from their document, my lord, at page, my lord, 20, annexure P4, paragraph 2, lords, you can find there is an allegation of overdrawal, my lord.
That is separate thing. For allegation of overdrawal, deduction, if it is permissible, you can deduct.
On that
But
basis, my lord,
how the pension can be
on that basis,
fixed
my lord, on that-
based on a lower basic pay?
my lord, on that allegation, my lord, firstly, the pension was returned, calculation was returned. Subsequently, it was sent, and on this calculation of my lord, lower amount of 50,600, this was been finally calculated. This is what I found from their document. I have not received any instruction.
If anything is required to be refunded,
Yes.
or if any recovery is made from the petitioner, then there is a separate procedure.
Yes.
But pension has to be fixed based on a correct basic pay.
Yes, my lord, that is.
Otherwise, for even after recovery, this will continue. Payment is to be made at a lower rate. That is not permissible.
What I found, my lord, what I
It is
understood, my lord.
alleged in the writ petition that the pension has been fixed based on the basic pay of 58,400, not on the basic pay of 60,400, 60,400. Now, 58,600 based on basic pay of 58,600 pension was paid, though petitioner's last basic pay was 60,400. Now, for recovery, that is not the way to recover the amount. If there is a if it is a case of excess payment, because suppose the rupees 2 lakh is to be recovered, that can be recovered if it is permissible. Now, that recovery is to be made from the pension or from the gratuity or other benefits. But for that, pension need not be fixed at a lower rate. After recovery, petitioner will get pension at the lower rate for wrong fixation of pension.
What has fallen from your lordship, my lord, I bowed down to that. But as I don't have any instruction, I cannot see that.
Obtain instruction. Obtain instruction.
And
Issue. Supplementary affidavit is filed on behalf of the petitioner today and same is taken on record. Stop. In the supplementary, next paragraph, in the supplementary affidavit, pay slip for the month of July 2024 is annexed, from where it appears that petitioner's last basic pay was rupees 6400. Stop. It is alleged on behalf of the petitioner that ignoring the last basic pay of the petitioner, that is rupees 6400, pension was fixed based on basic pay of rupees 58,600. Stop. Petitioner prays for consolidation of his pension. Next paragraph, learned advocate representing Union of India has prayed for accommodation to obtain instruction. Next paragraph, concerned respondent authority is directed to file a report disclosing as to why pension of the petitioner was fixed based on lower basic pay as indicated above. Stop. Next paragraph, let such a report be filed by fortnight from date. List the
4
matter
weeks, my lord, 4 weeks, 4 weeks. Because last 4 weeks they have not been able to, my lord,
by fortnight from date. Then I will direct to file it by 7 days.
lordship.
Achha. List the matter under the same heading for further consideration on 9th February 2025. 2026. 58600. 58600 and the higher 58,600 600. আর ওটা 60,400. Next.
Item number 7. I am for CSTC led by Mr. Vihan.
Yes.
Lordship, as per my instruction, Lordship, I hand over it, Lordship. They already given, Lordship, undertaking that if any excess payment made, they shall be refunded to the government, Lordship. Kindly, Lordship, see the second page, Lordship. Second page, the undertaking portion, Lordship.
It's an option undertaking. I have not. Now, where is the excess payment?
Lordship.
Where is the excess payment?
Excess payment, Lordship. Excess payment.
When this undertaking was furnished? When this undertaking was furnished?
Lordship, date is not particularly mentioned, Lordship.
Yes, 28 August then. At the bottom of page 2, that is marked as page 17.
Yes.
That is the usual format for at the time of revision of pay, getting the benefit of revision of pay, an employee is required to submit this undertaking while opting higher scale of pay.
Lordship, in that case, Lordship
But
petition,
for that, you cannot lower down the basic pay of an employee in order to release less amount towards leave salary. For recovery, there is other procedure. You will serve a notice that yes, this amount is found to be paid in excess. You are required to refund the amount. That court can understand. Whether it is permissible or not in terms of paragraph 18 of Rafik Masi is a different thing. That court will consider.
yes.
But for that, you cannot lower down the basic pay of an employee at the time of retirement in order to release less amount towards leave salary. That is not the procedure. I am not saying that you cannot recover. You can recover in an appropriate case. But if you downgrade the basic pay of a retired employee, suppose rupees 50,000 is paid in excess. After recovery, what I was telling in the previous matter, after recovery, it has got a cascading effect. After recovery, petitioner will get less amount till he remains alive. Yes, Mr. Bihani, for payment of excess, for refund of excess amount, basic pay cannot be lowered down.
No.
That has been done in the present case.
Well, we'll make our submissions, Lordship will decide. We'll make our submissions, Lordship will record and decide. It cannot be done.
Yes.
Only thing is that, my lord, there is I do not know, there is an undertaking. I do not know if it had been shown to your Lordship.
Yes, that has been shown.
That has been shown.
Very ably shown by your junior.
That is it.
That is a usual undertaking.
That is usual undertaking.
At the time of opting for higher scale of pay. Yes. Everywhere you will find it.
Not only that,
but the issue is different.
Yes.
Issue is that the basic pay of the petitioner was lowered or reduced from 45,000 to 43,700. How that is permissible, I am asking you.
কাকা কোথায় লোয়ার এটা কমিয়ে দে আমার সেটা কি করে হবে বাবা দে বল বল
পিটিশনের পে স্কেল গুলো দেখো
basic pay also Sajjan sir will appear yes from 45 to 40.
How that is permissible?
That is true, that is not permissible. Basic pay cannot be lowered.
So, have you obtained instruction that what was the petitioner's basic pay on the date of return?
My instruction to the effect is this.
You have obtained instruction on a separate issue.
No, I tell you,
that is with regard to refund. Refund is not the issue here.
Not the issue. My lord, I tell your lordship, the only instruction to this aspect which I have received is, when I recollect, that initially career advancement scheme was granted to him at the completion of 10 years. The first career, he was entitled. Secondly, one of promotion ought to have been granted. Instead of the promotional benefits, second career advancement scheme was again granted to her.
Yes.
Now, the authorities possibly found that the second career advancement is due to mistake, the promotional benefits ought to have been granted, but that possibly resulted in this.
That resulted in excess payment.
Excess payment.
Excess payment that needs to be recovered.
And the promotional benefits granted.
For that, Mr. Bihani, there is a separate procedure.
Basic pay cannot be altered.
Survey notice.
Basic
then,
pay, yes.
But basic pay, if it is basic pay is downgraded, in that even rest of his life, he will get less
salary.
Less pension.
The entire pay scale
is permissible.
No.
Now, have you obtained any instruction that what was the basic pay of the petitioner?
No.
So you ought to have obtained instruction.
And if the basic pay has been reduced, it cannot.
That is not the instruction this court wants.
I followed you, Lordship.
Because the case which is made out in this writ petition is this, that petitioner's basic pay should have been 45,000 on the date of return.
It has been made 43,000.
But it was considered that it was not 45,000 but 43,700. Now, as a result whereof less payment was made towards leave salary. That is the case.
I tell you, Lordship, in my respectful submission, basic pay, if you altered, cannot be altered.
To obtain instruction relating to X issue, you have obtained instruction relating to Y issue.
দাদা এরকম
obtain proper instruction and
the
come
basic
back.
pay cannot be altered.
No order, obtain proper
No,
instruction
no,
and
I
come
don't need an order.
not this week করে দাও।
Yes, yes. ঠিক আছে।
Obtain instruction relating to basic pay, that what was the basic pay of the petition
And whether or how can it
and whether it has been lowered down and fixed the pension accordingly, or considering the appropriate basic pay, pension was fixed.
Absolutely. কি হচ্ছে বলতে না বেসিক পে কমানো যায় নাকি?
Please call the list. Item number 8.
My lord, I'm appearing for the petition. It is the same matter, similar matter as item number 7, your lordship. My pay scale has been reduced, your lordship, and
Who is appearing for the authority?
Mr. Bihan is appearing.
So where is he? Not this week, same matter.
Lordship, same.
পরপর দুটো রেখে দেবে যেন আছে।
Item number 9.
My lord, I am for the petition. My lord, affidavit of service.
Yes. You have served upon the respondents.
Yes, my lord. My lord, I have joined as Anganwadi helper in the year 2007 after proper recruitment process, and after that I am working over there for 18 years till date. My lord, I have made several. In the meantime, I have enhanced my qualification from non-metric to Madhyamik in the year 2021. So there are there is some provision for giving promotion. Anganwadi helper.
Today, you are seeking promotion to the supervisor.
No, my lord. Worker from helper to worker. Just to get some enhancement, my lord. This is the social status like that. And for that reason, I have made several representation before the authorities, but that is not considered till date. And last of all, my lord, my learned advocate, by my instructions, one letter also sent for demand for justice, just for one promotion. And like my colleagues, different, they are also getting promotion in different
Have
time.
you participated in the promotional process?
Yes, my lord. Once I have appeared at the examination.
When?
2014. But that time that
not selected.
Not selected because.
Then where is your right?
No, my lord. That time actually what happened? That time the circular was there that in 2013 they have made one circular, a memorandum that everybody should be class 10 pass. But that time I was not class 10 pass. But still there are 11 candidates. They got promotion over there. Some of them were not also.
That is different thing.
Yes, my lord.
14.
But
after that also there was a promotional process.
There was another examination that at the date of examination I got accepted.
There is a promotional process.
Yes, only once. After that, only once in the year 2023, there was an exam. Unfortunately, that very day I got a severe accident. That's why I could not.
What can be done? If you are not participated in the promotional, if you have not participated in the promotional process, how your promotion can be affected?
No, my lord, authorities also not taking any other promotional. Only 2019, once they have given one promotional list, but no, nobody knows that how this thing happened. And after that, in 2024, one examination, one circular was there, but no examination held after that.
Issue. Affidavit of service filed on behalf of the petitioner is taken on record. Next paragraph. Petitioner is working as Anganwadi helper and has prayed for promotion for being engaged as Anganwadi worker. Stop. It is submitted that petitioner is petitioner is working as Anganwadi helper for a long period of time, and she has acquired requisite qualification for being considered for the post of considered to be promoted as Anganwadi worker. Next paragraph. State respondents. Union of India. Union of India, and who is for the state? State Union of India is represented by learned advocate. Next paragraph. From the submissions made on behalf of the petitioner, it appears that petitioner previously participated in it appears that petitioner's candidature for being promoted to the post of Anganwadi worker could not be considered previously, since at the material point of time when promotional process was commenced, or when promotional process commenced, petitioner did not have the requisite qualification.
No, my lord, once
in 2014, did not have the requisite qualification. Stop. Subsequently, in 2023, promotional process was initiated when petitioner could not participate. Stop. Next paragraph. Unless petitioner participates in promotional process by offering her candidature, petitioner is not entitled to be promoted to the next higher post, that to the next higher petitioner is not entitled to be promoted as Anganwadi worker. Stop. Next paragraph. Writ petition is disposed of, granting leave to the petitioner to participate in the promotional process when initiated by the concerned respondent authorities, and it is expected in the event petitioner participates in the next promotional process, her candidature shall be considered in accordance with law. Next.
Item number 10. I am appearing on behalf of the petitioner.
Yes.
So this is the case. Well, the petitioner widow has come before your lordships for claiming for monetary compensation. In the year 1995, husband of the petitioner died during service.
1996.
1995. Well, immediately after death of the husband of the petitioner made an application for compassionate appointment in terms of the condition and laid down in the memorandum of 6. Since 1995 to till date.
1996 died.
No, 1995. The 25th April 1995, husband died.
26th April, 5 p.m. 26th April.
Oh, here 25. Anyway, date of death, no, 25th April 2020, 1995. Page 28.
What you are praying for?
29. Now, I am praying for compensation, monetary compensation, because I am the overest at present. In the year 1995, husband died, and immediately the petitioner made an application for compassionate appointment. But the compassionate appointment was not given immediately. Then 2015, I made an application that my age is over, above 45. So the petitioner pair for giving appointment to person Gautam son, but that was not also been considered. Now, the petitioner is claiming for compassionate appointment.
Compassionate appointment.
Sorry, MMCC. The issue,
monetary cash compensation.
This issue has been decided by this honorable court. One judgment. Lordship knows the Maya Bauri. Here, this is my claim at present.
Yes, why petitioner is not being paid?
The formalities are not being done. So far as the current is concerned, Lordship can give me an interim direction. I will comply it immediately. But the problem is, she said that I am not taking it, you give me employment. At that point of time, she refused it because she knew that if she is taking this, employment will not be given. So that time he dragged on. Then he tried to bring his son.
But under the coal wage agreement, candidates are entitled to get monetary cash compensation if compassionate appointment is not provided.
Yes. So now what they do is they avoid the compensation amount.
Yes, because
To take the employee.
his road for appointment on compassionate ground will be shut.
Yes.
Yes.
So they usually now when they come back to this court, then
So
say
we pay monetary cash compensation.
current there is no objection to it. For the current there is no objection to it. Lordship, here he is asking arrear with interest. That's the problem, Lordship. That's why we are contesting. If she makes an application to me, Lordship, I can assure your Lordship, keeping the matter pending, we will continue with this present one. We have no.
Let it be paid first.
Interest in this judgment, interest, it has been denied. My lord, I have filed appeal. Well, appeal court has taken into consideration that will be prior to 29.
Have you made an application for MMCP?
Yes. My lord, page 61. Page 61.
So let me direct the authority to release monetary cash compensation by 4 weeks from date on compliance of necessary formalities. And let the matter be kept pending and appear on a particular date.
Only interim order Lordship was passing for passing compensation from immediate.
Let them take a decision and release the amount towards monetary cash compensation.
Lordship, his representation dated 21st March. We will look into it. Lordship can dispose it for a while. We will look into it. We will grant him whatever she is entitled. We are a government company. We cannot withhold his money. So we will release. And if he is agreed,
subject to correction. Yes. But the entitlement from the date of death, that has to be decided.
Husband of the petitioner, affidavit service filed on behalf of the petitioner is taken on record. Next paragraph. Husband of the petitioner died in harness. Died in harness on in the month of April 1995. Stop. You first applied for appointment on compassionate ground. Petitioner applied for appointment on compassionate ground.
Page 34.
But same could not be considered. Stop. Thereafter, petitioner made an application for payment of for release of monthly monetary cash compensation within bracket MMCP in view of untimely death of her husband. Stop. Petitioner prays for direction for payment of monetary cash compensation along with arrears and interest. Next paragraph, Mr. Land Advocate representing Eastern Coalfields Limited has submitted that once an application is made seeking payment of monetary cash compensation, same needs to be application is made seeking payment of monetary cash or seeking payment towards MMCP. Steps are required to be taken in accordance with law for release of such benefits. Next paragraph. Having considered the respective submissions made on behalf of the parties and taking note of the fact that an application has been made by the petitioner seeking MMCP on 21st March 2025, who is to release jail manager? Jail manager, Eastern Coalfields Limited. Being respondent number. No, jail, there is no post of jail manager as such.
Page 5. Respond number 5.
Respond number
5.
5. Jail manager within bracket ECL Satgram Sripur area at Satgram Sripur area, comma, Poschim Bardhaman, being response number 5, is directed to release MMCP benefits to the petitioner in consideration of her application dated 21st March 2025 by 4 weeks from the date of communication of this order. Stop. While releasing such benefits, response number 5 shall follow the observations and directions contained in the judgment dated 20th May 2025 passed by a coordinate bench on a writ petition being WPO 333 of 2025 within bracket Maya Bauri versus
My lord,
Messrs. Eastern Coalfields Limited and
that
others.
might not be very.
Next paragraph. রিট পিটিশন স্ট্যান্ডস ডিসপোজড অফ দেন জেরক্স সার্টিফিকেট কপি, যেখানে পিটিশনারের সাবমিশনটা হয়েছে ওখানে লাস্ট লাইনে অ্যাড করো রিলায়েন্স ইজ প্লেসড অন দ্য জাজমেন্ট ডেটেড 20th May 2025 of a coordinate bench passed on a writ petition being WPA 33 of 2025 within bracket Maya Bauri versus Messrs. Eastern Coalfields Limited and others. হলো তো? এবার আমি যেখানে অ্যাড করলাম এই লাইনটা মায়া বাউরির, ওটা একটু বলো। As contained in Maya Baudi Supra. Next.
Next is same.
না, এখানে আর দরকার নেই, ওই উপরে দিলাম বলে এখানে সুপ্রা করে দিলেই হবে। Yes, next.
Item number 11. The next is also same issue. 2005, the husband my lord died.
When died?
My lord,
October 2005.
October 2005. Initially, my lord, the application.
7th October 2005.
Yes.
Where is your application?
My lord, MMCC application, my lord, last page 45.
Compassionate appointment was
Yes,
not provided.
Compassionate appointment was my lord,
Provided.
made an application, not for me, my lord, brother-in-law of the employee, because he was a dependent.
So he and the compassionate appointment was made.
No.
Brother-in-law, man.
Is not part of the family.
That's normal. The direct, not indirect.
Very well. There is no. It is not a case
No,
of
no.
appointment providing appointment on compassionate ground. Issue. Same হবে, শুধু ওই ডেটটা করে দাও 7th October 2005 আর হ্যাঁ, আর অ্যাপ্লিকেশন ডেট ইজ 23rd July 2025. সেম অর্ডার। ওটাকে শুধু সাজিয়ে দেবে, ওই দুটো চেঞ্জ করে।
Item number 12.
Yes, item number 12.
Yes.
Yes.
In this matter, my lord, departmental proceedings culminated with the order of removal from service. Petitioner preferred an appeal. Appellate authority modified the order to that extent that reduced to the lowest stage of the time scale of pay for a period of 2 years with cumulative effect. Now, your lordship, I'll see this is the accidental fire.
Where is the order of the appellate authority?
My lord,
Where is the order of the appellate authority?
appellate authority. Page. Lordship, kindly come to page. Start from Annexure P10, 67. 68 is the page 68. Last paragraph is the penultimate portion of the order.
Have you preferred revision? Revisional application you have preferred. In the revisional application, order of the appellate authority was affirmed. Affirmed. Where is the order of the revisional authority? Where is the order of the revisional authority?
Revisional authority. You also can compute. Annexure T3. T3, 13, sorry.
Page 72.
Page 72.
And the order of removal from service by the disciplinary authority.
Well, logically come to page
Starts from page 47. সবচেয়ে বেশি কথা থেকে শুরু হচ্ছে
page কত?
47 থেকে শুরু
47
থেকে শুরু হচ্ছে Page 61, my lord, is the
Just a conclusion.
my lord.
It's an inquiry report starts from page 40.
47, 61 is the effective part, just my lord.
63 is the penultimate portion.
Page 62, it starts from page 62.
62 and last. my lord. যে আপনি কমিউনিকেশনটা আগে লাগিয়েছেন অর্ডারটা পরে লাগিয়েছেন ওই জন্য গন্ডগোল
So there is no scope for any interim order.
No scope.
Yes.
Last day, my lord, I have submitted before you.
No, there was a service was not complete. Affidavit of service filed on behalf of the petitioner is taken on record. Stop. You have challenged all the three orders. The next paragraph in the writ petition, order of the disciplinary authority dated 27 July 2022,
22.
whereby petitioner was directed to suffer removal from service
1 to 5.
is questioned. Stop. Order of the disciplinary authority dated 27 July 2022 was modified by the order of the appellate authority, which is annexure P10 to this writ petition. Thereby, on reducing punishment, petitioner was directed to suffer reduction of pay to the lowest stage in the present scale of pay at the appropriate level of pay matrix for a period of 2 years with cumulative effect. Stop. Order of the appellate authority was assailed before the revisional authority. However, revisional authority affirmed the order of the appellate authority, and such order of the revisional authority is annexure P13 to this writ petition. Stop.
Lord, subject to
Challenge has also been thrown
subject to Lord.
to the order of the appellate authority, to the orders of the appellate authority as well as revisional authority. Yes.
Lord, he has also preferred the mercy petition also before the.
Stop. Next paragraph. Union of India is represented by learned advocate. Stop. Next paragraph. There is no scope for passing interim order. Stop. Legality and validity of the orders impugned in this writ petition needs to be examined on exchange of affidavits. Stop. Next paragraph. Let affidavit in opposition to this writ petition be filed by 4 weeks from date. Stop. Affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Stop. A petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits.
Well, item number 13.
This matter, I have been instructed to pray for an adjournment on behalf of the petitioner. Mr. Govindo Kaur is appearing.
Yes.
He is suffering from illness. I have been instructed by his clerk to pray for an adjournment.
At the time of call, accommodation is prayed for on behalf of the petitioner.
Next time may be granted.
Since learned advocate is unwell. Stop. Hearing of this matter stands adjourned. List the matter. On 9th February 2026.
Item number 14.
For the next one. I'm late, right?
And my candidature has been rejected. Case 20 is the
instruction.
And instruction I've received, this is sandal cap feet, my lord, and I have a X-ray report which certifies the fact that there is. I'm sorry, this is bow legs and little feet, and
yes,
there's an X-ray report supporting my contentions. I've just handed over the X-ray report.
Well, at page 20 is the initial rejection order. Kindly have a look. Tremors, bilateral hands. 20, page 20.
That may not have been found in the review meeting. You have review when there was review, that was not found to be.
That was not found to be. Well, kindly take.
Tremors, bilateral
hand. Well, in state hand, some chill the hand. That is the problem.
Oh, tremor.
Tremors. Bilateral hand. This is the initial.
So he was declared unfit, then you preferred review.
Yes, paper review. Review is the page 21. And different. Cannot, there is no scope
What is written there, being the cause of?
Due to sandal gap, deformity in right foot.
Even the guideline says that when there's a sandal gap, the feet becomes wider, my lord, which prevents wearing of combat wear. And if there is prevention of wearing of combat wear, that person has to be disqualified. That is the guidelines, my lord, page 27 of the guidelines. Roman H, capital B. Capital B, subclause C, my lord. That is at page 4 of my report. Annexure R1, page 4 of my report, my lord.
Oh, sandal deformity.
Page page.
Now, tell me from that whether this is one of the reasons provided in the guideline.
My lord.
Show me the guideline.
Page 4, I have annexed the extract of the guideline.
Kindly take this full.
If my learned friend hands over the entire guideline, page 27 of the guidelines.
Page 27 of the guideline.
Of the
Yes, foot
guideline.
and ankle, under the heading foot and ankle.
Yeah, foot and ankle, my lord.
Absence of
Subclause B, my lord. B for Bombay. B, my lord. Presence of deformities of toe, acquired or congenital, including but not limited to conditions such as hallux, but not limited. So it can go beyond this hallux valgus, hallux, and such and such, that prevents proper wearing of combatized footwear. This is the issue, my lord.
working marching.
What is the indication of sandal gap deformities?
Sandal.
I am putting this question.
A sandal gap deformity.
It includes sandal gap.
There is no such.
What is sandal gap? It's a
Yes.
gap between the
last toe and the second toe, first toe and second toe.
is a term noticeable space between the big toe and the
Yes,
second.
first toe and second toe.
Yes.
That is
Resembling the gap in same sandals.
yes, that is not the case. Here not the case. I have no such problem, deformities. That's why I have challenged this.
Deformities are toes. Presence of deformities.
The investigation.
Just a minute.
I'm sorry.
And I am putting
Just a minute.
Such as hallux valgus, including but not limited to hallux valgus, hallux varus, hallux rigidus, lotus overriding to that events. Associated with
clause 6 of the
Wait. is why you are saying that it is not described in B, foot and ankle, under foot and ankle deformity.
There is no such specific indication. Well,
Hallux varus.
Hallux varus is not my case.
Yes,
it is his.
Hallux varus is your case, and they have
But
said so.
That can be
Hallux
stated in the-
varus is the specific case,
Matlab
and you
that-
search Google.
that-
Same thing. Sandal gap and hallux varus is same thing.
That is the specific ground they can rejected my candidature. But in the review medical examination order, there is no whispering that I have a hallux varus deformities.
But it says that hallux varus is sandal gap.
Matlab
It's a gap between the big toe and the second toe.
Yes, that is the matlab, can they go through that? Matlab, I'm putting this question as
No,
per
no,
the
that
device
in the
guideline.
report they are saying, in the report also they are saying that not permitted. Just a minute. Sandal gap is hallux varus, within bracket hallux, the same thing.
Matlab, that can be ascertained in the matlab, kindly have a look on the guideline. They cannot go beyond the
It is
scope
part
of
of the guide. Acha, Bosho to,
Matlab,
part of
this
the
is- matlab, kindly
guideline.
have a-
Part of the guideline is
Is
annexed.
all right. Matlab, this is the review guide, medical board instruction. Matlab, kindly have a look.
Yes.
Yes, this is the thing. Matlab, they have not handed over that. And specialist opinion
paragraph-
also not handed over.
Paragraph Roman 7B, subparagraph B.
No,
they have
matlab,
relaxed.
clause 6 of the review medical guideline board.
Show me your
Yes.
guideline.
First clause A. Matlab, this is the guideline for the review medical examination board. 6(1) A. Matlab, I have given that. The clause annex, matlab, I have indicated that clause. Clause 6.
You are relying upon clause 6.
Clause 6.
Yes.
Guidelines for review medical examination in the Central Armed Police Forces. Heading. Matlab, clause 6A. Review medical board shall examine the candidate specially for the deformity for which the candidate has been declared unfit.
For the deficiency.
The deficiency for which the candidate has been declared unfit.
No, I am not on this. Show me that hallux varus is not a ground under 7.
No, I have not said so. It is a valid ground. They can reject me. But in the detailed medical examination, they have not found me as I have a hallux varus or sandal gap deformity or whatever the name may be they can use medically. But in the review medical examination, when examining my hand, they found my deformity in my leg. It is beyond the jurisdiction of the review medical board. And I have no such deformity.
Come to page 91 of your revised guidelines.
91.
Yes.
Page 91 means, my lord, the bottom portion.
No. Page 91.
My lord, bottom portion is
It's not page 17. Page 17.
27.
Yes, page 27.
27. Foot and ankle.
Then it is hallux varus is the ground.
Hallux varus is the ground, but hallux varus is no. I have no hallux.
Anything more? Anything more you want to submit?
Yes. Two ground. Two things I shall submit. My lord, the X-ray report that has not been shown, that has not been indicated that I have a hallux varus deformity. That has not been first ground. And second ground is the specialist opinion. They have not been supplied to your lordships.
Yes.
They have taken that.
Where is the X-ray report?
Yes.
X-ray report is page 5, my lord. It says sandal gap deformity, which is the same as hallux.
And a specific case, I have not such sandal gap deformity. I have a normal foot.
X-ray report says sandal gap deformity.
Yes, that has been not hallux varus. The specialist, thereafter they have taken specialist opinion, the orthopedic opinion. This board is no, there is no orthopedic surgeon. They have obtained the orthopedic opinion. Kindly have a look the what the orthopedic opine.
Sandal gap deformity.
Orthopedic opine as per the
Kollani Nodia, WBUHS, that hospital, government hospital, government of Department of Health and Family Welfare, College of Medicine, JNM Hospital, Kollani Nodia, sandal gap deformity, right foot.
That has not been mentioned that hallux varus. My first point is that they cannot go beyond the scope of the.
In terms of the order dated 15 December 2025. A report dated 1st January 2026, signed by Commandant within bracket ESTTA establishment, close bracket, for Inspector General Border Security Force South Bengal Frontier. FTR is Frontier, is filed along with supporting medical documents, and same is taken on record. Next paragraph. Learned advocate representing the petitioner has submitted.
22, my lord, the Sagar
has
Datta
submitted. I have heard you. Please don't disturb this court. Please take your seat. I have heard you. Please take your seat. I have, while dictating, please don't make any running commentary. Please take your seat. Enough is enough. Please take your seat. I have heard you. Please take your seat. Please, Mr. Kundu, take your seat. I have heard you.
Yes, madam.
Don't disturb this court when court is dictating the order. If I require any information, I will ask you.
No, this is my duty.
It is submitted by the learned advocate representing the petitioner.
If I miss anything.
That in connection with selection of the petitioner for the post of Constable GD under Central Armed Police Forces within bracket CAPF, petitioner had to participate in detailed medical examination on 24th November 2025, and petitioner was declared unfit on the ground of না 24th November ভুল হলো। On 20 November 2025, when petitioner was declared unfit due to tremor, TREMOR, due to tremor in hands. Stop. Petitioner preferred review, petitioner preferred review, and in review medical examination, which was conducted on 24th November 2025, petitioner was declared unfit due to sandal gap. SANDL, due to sandal gap. Stop. It is submitted that when in detailed medical examination for one reason petitioner was declared unfit, in review medical examination when such reason was not found to be genuine, for a different reason petitioner ought not to be declared unfit. Stop. Next paragraph. In addition thereto, it is submitted that X-ray report does not support the view expressed by the medical experts in review medical examination held on 24th November 2025. according to the petitioner, sandal gap and hallux varus HALLUX VARUS hallux varus are not same deformity. Therefore, petitioner should not have been declared unfit. Next paragraph. On the contrary, it is submitted on the contrary, learned advocate representing Union of India has made submissions based on review medical examination report dated 24th November 2025 and the report furnished on behalf of respondent authorities dated 1st January 2026. Next paragraph. It is true that on different reason petitioner was declared unfit by review medical board on 24th November 2025. Petitioner was declared unfit on the ground of tremors in hands, whereas in review medical examination, petitioner was declared unfit on the ground of sandal gap, but not on the ground of but not due to tremors in hands. Question is whether deformity pointed out by the medical expert in review medical examination is covered by the deformities delineated in revised guidelines of revised uniform guidelines for review medical examination in Central Armed Police Forces and Assam Rifles or not. As per deformities of foot and ankle described under clause capital B korbe, clause B, hallux varus is one of the deformities. In the report filed today, it is stated that sandal gap and hallux varus is identical deformity and same is identical deformity. X-ray report dated 22nd November 2025, which is annexed to the report filed today, also suggests it is a case of sandal gap deformity. The next paragraph. This court is not a medical expert. Therefore, issue involved in this writ petition needs to be decided based on opinion of medical experts. As it is found that sandal gap / hallux varus is one of the deformities for which a candidate needs to be declared unfit, court finds no incongruity in review medical examination. Stop. Hence, no relief can be granted to the petitioner. Writ petition stands dismissed.
The picture shows different. Pentel gap and the Alex.
I have seen from the in each and every your case, I am required to consult Google.
Here the Google says two different picture.
Item number 15. I was seeking for some indulgence in this matter, if it can be taken up next week.
Why?
Instruction has probably not.
Not
come
this week.
through.
Okay, item number 15.
I'm sorry, I'm extremely sorry. The item number.
It's a different matter.
Yes.
Yeah, item number 15, I'm appearing for the petition. Your Lordship, here I'm eligible.
Just a minute, let me go through my own order.
November.
Rupees 9499 was deducted.
Was the deduction regarding PF volume, PF loan, that amounts to 9,499. But my lord, what my contention before this lordship is
So
provisional.
how much amount was deducted?
My lord, amount deducted was 93,486.
Where from you are getting these 93,000?
Lordship. Because if my lord will see the provisional leave balance, it comes to EL. My lord,
But in paragraph, page 12 says deduct 9499.
no. That was not so, your lordship. The deduction is
Come to
regarding-
page 12. Come to page 12.
Lordship, 12 I am reading, your lordship, the deduction.
Yes,
is
deduct
regarding
9499.
No, your lordship, PF volume, PF loan, that amounts to 9499. The provisional leave balance, what I'm entitled to is 62 days leave salary. It will come to earned leave. Kindly the last column, earned leave 62.726063. So I'm contending the 62 earned leave I am having in my credit, your lordship.
62 days leave.
62 days leave. So which amounts if I calculate the leave salary,
Therefore, this order requires correction.
Correction. The correction recovery of instead of 4,26,063, it will come to 93,486.
From where you getting this 93,486?
Lordship, if I calculate the leave salary,
It is not there on record.
No,
That is based on your
no.
calculation.
Lordship, because this leave salary indicates that I'm entitled to get the leave salary of 62 days. But while calculating my leave salary, if I will calculate, your lordship, the leave salary comes to 1,25,000. 62 days leave, your lordship. So now if I received the leave salary.
We will come back tomorrow.
I can
Lordship.
complete in 2. Your lordship gives me 2 minutes.
Here is the original side day next time.
But then kindly keeps it not tomorrow. Tomorrow will coming late. Kindly keeps it on any day after tomorrow. Any day. Because I have
Day after tomorrow is the application date. So therefore, maybe not this week.
because I can lordship can dispose it of in 5
Really, when it will be called on, you will.
minutes.
Yes.
May I have my lords kind leave to mention a matter? Well, it was a matter of 2024. Twice direction has been given to file the affidavit in opposition. Nothing has been done. Last direction was on 5th of August. It was time frame to be given opposition by 2nd September. But we are in January. Well, it's a very limited question, two divergent decision of the two honorable division benches. That has to be referred to the larger bench. But that is the precise prayer before Lordship. If my lord may kindly keep it.
There are certain hearing matters. Court is not taking up any hearing matter. Wait. Yes, please call the list.
My lord, may I permitted to mention one court application, your
Yes.
lordship? Court application, your
When you
lordship.
have filed it,
6th of January, lordship.
hand over the slip. Next Wednesday. Sub note. Oh, notice to thakbe. Yes. Next.
Court applications under item number 1, Shangal Kumar Maji.
Item number.
Oh, ঠিক আছে.
Item number 1, your lordship, Mr. Parthoko is appearing for the petitioner, your lordship. Due to some personal difficulty, he is not able to come today. Praying for not.
My lord, Miss Tanushri Dasgupta is appearing for ECL, my lord.
She has also not come.
No, she has come, but she's on legs before another court, my lord.
At the time of call, learned advocate, at the time of call, on behalf of the petitioner, accommodation is spread for on personal ground of the learned advocate. Stop. On behalf of respondents also. Which respondents?
ECL, my lord.
ECL. On behalf of Eastern Coalfields Limited. Accommodation is also spread. Stop. List the matter. Next part. List the matter under the heading, under the same heading in the monthly combined list of February 2026. Next.
I am for the petition. I am for the
I
petition.
am for the state lordship.
Interest on delayed
I am
payment
for the
of one of the person retired on 30th September 2024 and provident fund was paid on 8th August 2025. But this order your lordship has passed in other matters. I have made the necessary incorporation.
Calcutta State Transport Corporation.
My lord,
Calcutta Transport
Corporation.
This is
West Bengal Transport
West Bengal.
West Bengal Transport Corporation. Show me the order. When petitioner retired?
My lord, 30th of September 2024.
Just a minute.
30th of September 2024 and provident fund was paid on 8th of August 2025.
Now entire provident fund has been paid.
Yes.
So you are praying for interest on provident fund. Only interest on provident
No
fund.
interest on the delayed.
Who is for the state?
State is appearing online.
Yes, who is appearing for the state? Unmute yourself. Unmute.
May I audible lordship?
Yes.
I am appearing on behalf of state lordship.
Provident fund was paid on 8 August 2025. এটা দেখে কারেকশন সেখানে একটা আমিও বলছি যে কনসার্ন অথরিটি হবে, হ্যাঁ কারেকশন গুলো সেম is disposed of.
Grateful Lordship.
And I am appearing for the petitioner.
My lord, I am appearing
If
for
my lord may kindly looks into the last order, particular lordship on 24th of.
My lord, I am praying before your lordship 7 days accommodation, my lord. To file the affidavit in
Last occasion also you prayed for accommodation.
last date, my lord, you directed me, but today the concerned authority is in the Ganga Sagar Mela. That's why.
Petitioner's PF has not been released.
Yes, my interest on good.
PF. PF then. Principal amount with that.
Issue. At the time of call, Mr. Shahi learned additional government pleader has prayed for accommodation to file report in terms of the order dated 24th December 2025. Time to file next paragraph. Time to file report stands extended by fortnight. Stop. List the matter under the same heading for further consideration on Fourth February 2026.
Grateful, my lord.
File report and disclose how this allotment was made
My lord.
for payment of provident fund. Yes, sir.
Grateful.
বলা আছে তো ইন্ডিকেট করা আছে তো, হ্যাঁ
Under Article 226 from item number 4, only and others.
If my lord may kindly see the last order.
মান্থলি লিস্টে দাও। কত লাগলো এটা? Yes.
There were two orders. On 3rd December, my lord directed me to serve a notice upon the state advocate. But that was complied with, but erroneously that was kept in another file. I could not produce before your lordship. So my lord was pleased to pass a similar order on 17th of December. But I have again served. The order, both the order has been complied with, but erroneously earlier order compliance was not in this file. It was erroneously kept in another file. I could not produce before your lordship. This is the communication. This is a letter pursuant to your lordship's earlier direction.
But today nobody is representing.
Yes, I have again served. Pursuant to your subsequent direction, I have again served.
We'll ascertain who is representing the state.
My lord.
Not today. and inform Mr. Bihani,
Fine. Let them,
representing the corporation, Calcutta State Transport.
at least let them an order to that effect. I will be communicating your lordship's order.
Inform. Next. Not today.
Item number 5, Mithilesh Kumari.
Yes, my lord, I'm led by Mr. Partho Ghosh, your lordship.
Yes.
Lordship, they prayed for time on last occasion for filing the report, your lordship. That has not been served, your lordship.
You are seeking time on what ground?
Mr. Partho Ghosh, he is out of station, your lordship. Personal ground, your lordship.
Take it out.
Well, the report is ready.
File your report.
May the report be taken on?
You are representing whom?
Lord, I am
Which respondent?
respondent number 1, 2.
Eastern Coalfield.
Yes, ma'am. Eastern Coalfield.
File your report.
I have filed the report, Lord. I am giving
Take
a
it.
copy to my lordship.
A report in the form of affidavit affirmed on 13 January 2026 is filed today on behalf of Eastern Coalfields Limited and same is taken on record. Next paragraph. However, accommodation is prayed for on behalf of the petitioner on the personal ground of the law and advocate. Stop. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Grateful.
Grateful. Kindly, lordship, kindly record. I have served a copy of the report upon the.
আচ্ছা এখন একটা report kept on record. Copy of the report is made over to the learned advocate representing the petitioner. ও পরেই দিয়ে দিন ফার্স্ট প্যারাগ্রাফে যেখানে বললাম যে is taken on record তারপর।
I am grateful.
Item number 6, Srimati Trisha Mukherjee.
In this matter, my lord, I am appearing for the petitioner, your lordship, led by Mr. Partho Ghosh.
Praying for time.
Yes, your lord.
You are praying for time.
Yes, your lordship. My lord, may I permitted to file my exception to their report?
Yes.
Exception to their report, your lordship. Exception to their report, your lordship.
No, file on the next date.
Lord.
So, at the time of call, accommodation is paid for on behalf of the petitioner on the personal ground of the learned advocate. Next, however, ECL, Eastern Coalfields Limited, is represented by learned advocates. Next paragraph. Hearing of this matter stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Grateful.
Next.
Item number 7, Sadhana Bauri.
This matter, my lord, I am praying for 1 week time to file my exception, your lordship.
But report may be taken on record.
You are representing whom?
ECL.
ECL.
It's been already been served.
What you are filing
The report, where there was a direction to file a report, my lord. I have
by the
put up
previous
copy.
bench,
My lord,
by a coordinate bench. Where is the report?
given, my lord.
রিপোর্টটা দিয়েছো এখানে affidavit of service. Where is the report?
এখনই দিলাম যে
হ্যাঁ এখনই তো ফাইল করলো বললো তো
Copy served.
but I have served the copy to them, my lord. Copy has been served.
by which order there was a direction to file a report?
At first order, my lord. Then I could.
Probably 12th August. Just a minute. Let it appear under the heading hearing because in the order dated 12th August 2025, coordinate bench observed that there is no scope for passing any interim order. Issue. Learned advocate representing Eastern Coalfields Limited. has filed a report in the form of affidavit affirmed on 15 December 2025 and same is taken on record. Stop. Copy of the report is made over to the learned advocate representing the petitioner. Stop. On behalf of the petitioner, next paragraph, on behalf of the petitioner, accommodation is prayed for to file an exception to this report. Next paragraph, let an affidavit taking exception to this, let an affidavit taking exception to this report be filed by fortnight from date. Stop. Next paragraph, list the matter under the heading hearing in the monthly combined list of February 2026.
Item number 8, Kailali to
I'm praying for not today, my lord.
For the respond. আছো 8 নম্বরে 500 বসে আছি তো
Which respondent?
Look, I appear for the Eastern Coalfields.
Eastern Coalfields.
There is a affidavit direction, your lordship.
Lordship gives me 1 week time, my lord. I will not come.
You have not filed affidavit?
No, the
Why?
advocate on record.
Pay cost.
Advocate on record, Mr. Pradipto Bas was suffering from asthmatic problem. My lord. That's it. Nothing else.
But this order was passed on 19th
Yes,
August.
he is in some problem. But
A winter problem. It is a problem in winter.
But he told me so. Gives me 1 week time, I file it. My lord. That's all. এক বছরের মধ্যে করবে।
Respondent shall file a report. File on or before September 10th. Issue.
ECL এর নেমটা অ্যাপিয়ার করছে লিস্টে যে এমসিসি ও এমএসসি ও চেয়েছে
Not Das, no?
মান্থলি কম্পেন্সেটরি ক্যাশ কম্পেনসেশন
At the time of call, Mr. Devnath Ghosh, learned senior advocate representing Eastern Coalfields Limited, has prayed for extension of time to file report in terms of the order dated 10 December 2025. Stop. Next paragraph. Time to next paragraph. Time to file report stands extended.
রিপোর্ট দিতে বলেছে I leave it to you, Lordship, whatever time.
Respondent shall file. Time to file report stands time to file report on affidavit stands extended by 7 days from date. Stop. Respondents, petitioner shall file an affidavit taking exception to this report by 1 week thereafter. Next paragraph. List the matter under the heading hearing in the monthly combined list of February 2025.
I'll do that.
Grateful.
No scope for passing interim order, let it appear under.
Only thing, my lord, whether the name of ECL is there in the list or not. That's the scope. And there are two conflicting views. Justice Arindam Mukherjee has a view. Justice Saraf has a view. So Lordship has to take my lord, which applies to the facts of the case.
My lord, I am appearing on behalf of the Eastern Coalfields Limited.
In this matter, your lordship, there is earlier
Yes,
direction.
direction, my lord, now the report has been
Yes.
prepared.
My lord, report not yet been served, your lordship.
Report not served upon.
The only my lord, here they are praying for my lord, compassionate appointment. It is under consideration before the ECL headquarter. And second thing, my lord, they have the area manager has offered the petitioner whether he is willing to take MACC without any.
Just
রেসপন্স করেনি তো কোন রেসপন্স করেনি তো ক্লায়েন্টকে দিয়েছে
রিপোর্টটা দিন।
Have you taken decision relating to
Yes, sir.
appointment?
So far the employment is concerned, my lord, it is pending before the headquarters. So far the
How
MS.
long it will be kept pending? For 11 years. It has been recorded by the coordinate bench. And what was your submission on the next week? It will be communicated to the petitioner.
And so
Yeah, you are playing with the fate of the petitioner
And
and,
so-
making wrong submissions. Come to the order passed by this court on the on 25th of February 2025. What is going on?
25th February. Ronak Singh.
My lord, he has been, she has been offered, my lord, monthly monetary cash compensation, my lord. It is also clarified in the event ECL is unable to provide compassionate appointment to the petitioner, then ECL should place before the court the computation as to the monthly monetary cash compensation from the date immediately succeeding the till
এটা অর্ডারটা অনুযায়ী করলে কোথায় দর্শক দেখেছেন
Do you have the copy of the order dated 25th February 2025?
Yes, no, no.
Yes, please come to the second page of the order.
Yes, well, it is also clarified that
Please read the second paragraph onwards.
Mr. Sengupta, learned advocate appearing on behalf of the ECL, has placed before this court an electronic mail dated 21st February 2025, by which ECL has to instruct him that the employment proposal of the petitioner is already under progress and is pending at ECL headquarters for final decision, which is likely to take some more time, for which the matter may be adjourned. Mr. Sengupta further submits that as per the instruction received by him from ECL, the decision regarding the petitioner's compassion appointment may require a further 1 month.
1 month's time. When this order was passed, 25th February 2025. Yes, please read it. Read it.
Yes. Considering the respective submission, the matter is adjourned till 25th March 2025. It is made clear the matter has been adjourned at the instance of ECL, and as such, the learned advocate for ECL should come with the specific instruction regarding the decision taken in respect of the petitioner's prayer for compassionate appointment. It is also clarified that in the event the ECL is unable to provide compassionate appointment to the petitioner, then ECL should place before the court a computation as to the monthly monetary cash compensation from the date immediately succeeding the date of the petitioner till February 2025, with accrued interest thereon at the rate of 6% per annum.
What about it was submitted that within a 1 month if the decision is to be taken? 25th February 2025. Already 1 year has passed instead of one month, and you have not taken any decisions. Even today you are making same submission. So let me direct the concerned authority to appear before me personally. Should be limit of everything. What is going on?
And
thereafter you will submit that time has lapsed. In the meantime, you are not eligible.
Now, so far MSCC is concerned.
Where is the decision regarding appointment on compassionate ground? Please come to the next order dated 22nd July 2025. Read the second paragraph. Let us understand. Read it loudly.
Accordingly, the appropriate...
Mr. Shaunak Sengupta, learned advocate appearing for ECL. Read it.
Yes, on instruction from his client, submits the necessary decisions shall be taken and communicated to this court within a week in the light.
Within a week in the light of the said order dated 25th February 2025, 22nd July 2025.
Accordingly, the appropriate authority shall file a report disclosing his decision.
And today you are filing a report without disclosing the decision relating to appointment on compassionate ground. What report you will file? Take it back. What is this going on? In the month of July, 1 week was prayed for, and in by this time already 8 months have passed, and you have not taken any decision. And due to change of court, now you are about to file the report. What is this? It's a report. Mr. Pal, is it a report to be filed before the High Court?
Certainly not.
So why you are filing it? Why you are filing it? There's a fun going on before me.
Well, kindly give 2 weeks time, my lord. I take the concrete.
This is a report to be filed before the High Court in terms of the order passed by the coordinate bench.
My lord, affidavit should be filed. Report should be filed in the form of an affidavit.
It's a child's play. What do you think? Don't try to outwit this court by filing a report which has no sense, which will make no sense at all. And twice court extended the order. Very well, file a report, pay cost rupees 70,000, 10,000 per day. Then your client will learn the lesson. I am extending time for 7 days for filing a report. Pay cost of rupees 70,000.
Well, kindly give one chance, my lord, then I'll retire from the matter.
and it is to be recovered from the person responsible for causing delay in taking decision on the application seeking appointment on compassionate ground. Who is the authority to take decision on the appointment on compassionate ground? He is making a research work. And a new theory will be evolved. Yes?
Kindly give
1 month, 7 days in July 2025, and today we are in the month of January 2026. Which authority will take decision?
No. It is the Pandaveshwar.
Let chairman come managing director Eastern Coalfields Limited appear before me on next Wednesday at 2 p.m.
Well, one chance given, otherwise, my lord, you will pass that.
Then everything will be set at right. I know these things. I know these things.
Well, one chance be given because earlier I was not.
How do you dare to file this as a report? You have two options. Either let the chairman appear before me, chairman and managing director, or pay a cost of rupees 70,000 for getting a time of 7 days to file report, which is to be paid to the petitioner. Choose one of the options. This is the performance of the officers and the advocates. I am very sorry to say this.
Kindly,
the worse than state government and the Union of India. They are more prompt than ECL. On a complicated issue of illness and other deformity relating to appointment in the post of constable GD, by fortnight they are filing a report with opinion of the medical experts.
And you also has engaged me. I filed it by.
And this is the way that compassionate appointment is to be dealt with. What Supreme Court has said in compassionate appointment, to provide immediate financial assistance, and this is the performance of the ECL.
Time was
this is the performance of ECL.
Well, I personally talk with them because they are dealing with the matter. Kindly give one chance, otherwise I return from the matter. I take the responsibility on my shoulder.
Issue. Tell Mr. Ghosh to appear in this matter on the next on Wednesday. Next Wednesday. At the time of call, Mr. Sushanto Pal, learned advocate representing Eastern Coalfields Limited, has prayed for 7 days accommodation as a last chance to file a report disclosing the decision on the prayer made by the petitioner for appointment on compassionate ground. Stop. Let such report be filed by Wednesday next, 21st January 2026. Stop. List the matter under the heading, under the same heading in the daily cost list dated 21st January 2026.
Grateful.
Item number 10, Mr. Govindo Kaur is appearing for the petitioner.
আচ্ছা, আরেকটা লাইন অ্যাড করো তো। Stop. In the event concerned authority of Eastern Coalfields Limited fails to file on a report on the next date, appropriate direction shall be passed ensuring personal presence of দেখি ফাইলটা Who is to take decision? Mr. Pal? This number?
Two, your lordship.
Two.
CMD.
Ensuring personal presence of chairman and managing director, Eastern Coalfields Limited, being respondent number 2 on the next date. Stop. Next paragraph. A learned advocate for the petitioner as well as ECL. Learned advocates for the petitioner as well as ECL are directed to communicate this order immediately to the chairman cum managing director, Eastern Coalfields Limited.
Great.
All right, item number 10.
Take it back. দিয়ে দাও, দিয়ে দিন।
Well, Mr. Govindakar is appearing in this matter. He's not well, has not come.
Govindakar.
Yes,
Yes, in the morning also accommodation is prayed for.
That's right.
He's for the petitioner.
He's for the
You are for ECL.
No, I'm
for ECL.
ECL.
Friend of mine, that's right.
At the time of call, you are for ECL. At the time of call, accommodation is prayed for on behalf of the petitioner as the learned advocate is unwell. Next one. However, Eastern Coalfields Limited is represented by learned advocates. Next paragraph. Hearing of this matter stands urgent. Next one. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Item.
Number 11, Simoti Beli Mahajan Tudu.
This matter, my lord, I appear.
Item 11 and 12, my lord, I'm praying for not today, lordship.
Mr. Ghosh is not there. Thou filed the. What is the matter about?
It's praying for MMCC and employment, my lord.
Any decision on employment
He has
on compassion
taken, and
ground?
That's why he has also prayed for quashing of 2 letters, my lord. That's why he has also prayed for quashing of 2 letters, by which we had taken
Quashing
that
of 2
decision.
letters.
2 letters
By which decision was
was
taken?
taken, my lord.
It was turned down.
Yes, my lord.
Now, whether the
So we wanted to pay
whether
MMCC.
MSCC was given.
No, we wanted to pay MMCC. That's why we issued a letter and asked the petition number 1 that you furnish these particulars and all these things. But instead of that, she has filed this writ petition.
So monetary monthly cash compensation is yet to be released.
Yes, yet to be released, my lord, unless and until, my lord. There are certain procedures, as your lordship knows, my lord. We have to go through those procedures. So we ask for the documents.
Issue. At the time of call, accommodation is prayed for on behalf of the petitioners on the personal ground of the learned advocate. Next paragraph. However, Eastern Coalfields Limited is represented by learned advocate. Next paragraph. Hearing of this matter stands urgent. List the matter under the same heading for further consideration in the monthly combined list of February 2026.
Reports have been filed.
Are you filing report?
No, reports have been already
Previous
filed.
It has been exchanged.
Yes, next.
Item number 12, Mari Shukurnuni Meheji.
Similarly, lordship, I'm praying for not today.
Report has already been filed and so.
Let's say আগেরটা যেটা করলাম সেম অর্ডার করে দেব সেম অর্ডার ঠিক আগের ম্যাটারটা ইউ আর রিপ্রেজেন্টিং ইসিএল
Grateful, man.
Item number 13, Gita Bauri, alias.
Govindakar is appearing. 13. 13 and 14.
who is for the ECL. At the time of call, accommodation is prayed for on behalf of the petitioner since learned advocate is unwell. Next, however, Eastern Coalfields Limited is not represented by learned advocate. Next paragraph, list the matter under the same heading in the monthly combined list of February 2026.
Item number 14,
Same to my lord.
Maji.
Same, who is for ECL? Same order, Govind Koral. HON'BLE, huh?
Restoration applications, item number 15. Vikramanu Das.
I'm for the applicant, my lord. It's a restoration application. On my ground, has been dismissed
When?
by 25. Thereafter, I filed an application. Some difficulties it has been, liberty has been given to fresh file. Within 2 days, I filed this. It has been
When it was dismissed for default?
25th July 2020. Have annexed it.
25th July.
Yes, ma'am. 25th July 2025, it has been dismissed for default. It was filed and it was appear on 28th August.
There are two writ petitions.
Two writ petition is there, and
But on 28th August 2025, there was an order
yes, ma'am.
by the coordinate bench.
Yes, ma'am. That,
The untrue facts are narrated.
yes, ma'am. That has been shown and liberty to file fresh. Again, I file on 2nd September. That has been annexed on.
What statements were made in those applications
I made a statement that
for which Mr. Mujumdar opposed
I stated,
in recalling application?
I stated there that I prayed for an accommodation. I requested to my junior to pray for an accommodation. This fact was written in my that application. Learned advocate requested one of his junior to junior colleague.
What are the grounds for
I went for
recalling? You have stated in which paragraph?
I went for admission of my child. On that day, I annexed that document also. Paragraph number paragraph number 3, my lord.
What are the facts you narrated in your first application for recalling?
Same has been narrated. Only one thing I have written, that one of my junior colleague requested to pay for accommodation. Only this part has to be only deleted next petition.
Yes, Mr. Mujumdar.
Other thing is
Paragraph 3.
Let him come with an application for condonation of delay. I shall explain.
Have you prayed for condonation of delay in this application?
liberty has been given. That's why I.
No, but this is beyond 30 days.
That liberty, though the liberty has been given, that's why. That's why I.
No, in the prayer, have you prayed for condonation of delay?
No, that has not.
Then I could have allowed it.
That liberty has the.
Here representing which authority?
There is a delay of either 7 days or 8 days delay. He has to approach for condonation.
But I am with Mr. Mujumdar is with me, my lord, in the same matter.
Representing which authority?
No, I am representing the private respondent.
Private respondent.
Judicial officer whose appointment is under challenge.
You are working.
Yes, I am a judicial officer. Somebody from Odisha is unhappy about my appointment. There is an application for making allegation aspersion against this honorable court in the matter of my selection. I have taken out an application under section 340 as well.
25th July, it was filed in July, August.
25th July, it got dismissed. It is either filed on 1st
2nd September.
or 2nd
2nd
September.
September.
So there is a delay.
You could have prayed for condonation of delay in this application.
The previous application was in within time. That liberty was given by the honorable.
File an application. Short application. Yes. File an application for no. That I do not entertain. In the prayer, you could have made a composite prayer.
Format B.
A recall of the order.
And secondly, my lord, just one more thing.
Condonation of delay. Matter could have been the application could have been disposed of.
Secondly, my lord, the application is not in the format of the original side rules, my lord. The prayer part is kindly see.
It appears, it is pointed out by Mr. Mujumdar, learned advocate representing the private respondent, that beyond the statutory period of 30 days, application was filed seeking recall of the order dated 25th July 2025. Stop. Next paragraph. Leave is granted to the applicant to file an application seeking condonation of delay in presenting recalling application. Stop. Hearing of this application stands adjourned in order to enable the learned advocate for the applicant to take necessary steps. List the matter under the same heading on by 2 weeks. You file an application on 4th February 2025 in Delhi cause list.
Similar.
Record appearance of Miss Manath. Who appears? She is appearing with you. No.
He is not the appearing for
High Court administration.
My lord,
Give your
we are
appearances.
for the private respondent.
Yes, give your appearances. হয়ে গেল দুটো ম্যাটারই সেম অর্ডার হলো তাই না ঠিক আছে সময় আছে তো ফাইল অ্যাপ্লিকেশন
Never know original seller.
एक मिनिट मृदुल के टाको तो এটা তো একটা 15টা হয়ে গেল 16টা তার মানে একই অর্ডার করিয়ে দিয়েছো তো
My lord, only one interference. My lord, item number 20, but there was a previous order of the coordinate bench permitting me to join the corporation. There was a stipulation that you should sign the agreement. That agreement copy was never forwarded to me, and as such, I could not join. But item number 20, if my lord may kindly keeps it next Wednesday, my lord, then I will be praying for an interim.
my
order.
officer nobody is there sorry
I was under the impression that it was taken up. Item number 20, my lord, I will.
no sorry now it is not possible
Item number 47 from monthly list. Monthly list of appellate side.
not today
Appear for the, make it not reloads. Make it not reloads.
not today
Item number 50.
He appeared on behalf of the petitioner.
other side
Yes.
not today because after original side generally appellate side now previously it was appellate side matters were taken up now after combined
yes.
list matters
Today also
court does
3:30.
not find time
Also
to
3:30.
very well not today
Item number 64.
আস্তে আস্তে ডাকো যদি অ্যাডভোকেট আসে গেলে
Respondent number 3, 4, and 5.
64 you are appearing
Yes, that's it.
just এখানে করো I could know.
Okay. Now, before opening the
নাটকটা দেখছি না তোরা ডেকে নিয়েছিল
পনেরো হবে তাই আরেকশন ভালো দিচ্ছে before
চেপে যায় চুপ করে আর্গুমেন্ট
yes
before opening this brief, my lord, there is a typo, my lord, the quotation of the rule that would be 2015, my lord, not would be 2019, my lord. Prayer A and B in both.
then how it is maintainable if your prayer is defective
No, no, not defective, my lord.
Yes.
The proper rule is annexed, my lord. The typo, my lord, instead of 15, my lord, rule is also annexed, my lord. That
so that is the main prayer rule 24A of the West Bengal District Court so and so rules 2019.
There is no
How
such.
that is maintainable?
Yes, my lord, I
You
brought up.
withdraw the writ petition, file afresh.
There is.
Because rule 24A is challenged of 2019. Now you are saying, no, it is not 2019, 2015.
There
Sorry,
is no
Mr.
such rule to 2019, my lord. To 2015 rule
Yes,
annexed, my
that
lord.
has to be,
There is-
because that is the main prayer.
There is typo, my lord. Kindly, my lord, consider that much.
If you go on, then I have to dismiss the writ petition. Otherwise, you withdraw it, file afresh. I will not permit,
typo.
because that is not a misquotation in the writ petition. In the prayer, rule 24A of 2015 rules was required to be challenged. Instead of 2015 rules, you have spelled out 2019. I will not entertain this.
My lord, that is, my lord, kindly bow down, my lord, on that.
No,
because
no.
there is no such rule of 2019.
If this defect is not in the prayer, then I would have allowed you to file an affidavit, supplementary affidavit. But the prayer cannot be amended by supplementary affidavit.
Not supplementary. My lord, if my lord permit, because of that, my lord, there is no such rule, my lord. That exact rule is annexed with my
That rule is under challenge,
Yes,
Mr.
that is-
Shamim.
Yes, I believe, my
That
lord.
rule is under challenge, and that rule has not been properly described. Try to appreciate my
But the year is.
no. Try to appreciate my predicament.
Yes, but
Because if as a mere reference this rule was quoted, then question would have been different. You have challenged a particular provision of this rule by wrongly describing this rule as 2019 rules instead of 2015 rules.
my lord, there is no such 2019 rules, but so there is no such.
Then what court will do?
If my lord court permit me to that just
No prayer.
instead of
No,
nine,
prayer cannot be amended in this fashion.
as my lord did.
Then file an amendment application.
Yes, otherwise,
Then the application will be hard under the heading application. No purpose will be substitute. It will take long time. Nowadays, that's why litigants do not want to file amendment application.
but my lord, if because my lord
Only remedy which is left open is to file an amendment application.
yes,
Now the choice is yours. You can file an amendment application. Then I have to direct that the matter to go out of list with liberty to take necessary steps.
if my lord, if because of that, my lord, my predicament is that, my lord, because the already my lord, notification floated, and the exam is, my lord, this matter is all about the
Whatever
exam.
may be the position, if it is not in form, I cannot take it up. Now, if there is a mistake in the year, there are prayer is not properly couched. If prayer is not appropriately couched, in that event, only option which is left open is to file an amendment application, or you can withdraw it, file afresh. Now, choice is yours.
But the predicament is in this matter is that, my lord, because already notification is there, the expert.
I cannot entertain this writ petition. I cannot grant you leave to amend the prayer. That I can. I never do this.
Then, my lord, I have to, because otherwise amended petition application. Then,
This choice is yours. You
that,
can
my lord,
you
then-
can
then,
file
my
an
lord, I have
application.
to, my lord, after refiling.
Prayer cannot be corrected by filing a supplementary affidavit,
Because this is
or
a
cannot be
I
clarified.
could say, my lord, this is a typo, my lord, purely typo.
Yes, so
My lord, give me a liberty to.
at the
that
time
I-
of call, Mr. Firdaus Shamim, learned advocate representing the petitioners, prays for leave to withdraw the writ petition with liberty to file afresh. Stop. Respondents are represented by learned advocates. Next paragraph. In view of the submission made on behalf of the petitioners, writ petition stands dismissed as withdrawn with liberty to afresh on self-same cause of action. Parties to act on the server.
Not all the respondent, because all the district judges have made party. I am appearing only for the district judge, respondent number 6.
Give you indication in your.
No. Otherwise, my purpose is.
Always you appear on behalf of district judges in every matter. So there is no wrong in recording your name on behalf of district judges of all districts.
Kindly record that, my lord, the deficient post. My lord,
Whenever service matter relating to subordinate courts are taken up, Mr. Mukherjee appears on behalf of district judge.
my lord, deficient post.
একটা লাইন অ্যাড করো document filed in support of depositing deficit court fee is taken. But I have not granted you any leave to file, directed you to file deficit court fees.
No, there is no required.
No, take it back. I will not record it.
Because of that, my lord, usually, my lord, one, if more than one file, my lord, I use.
No,
Simultaneously, I can.
দিও না।
But the money usually I inculcate in my practice. If more than one, I told
Yes.
my junior that always make the payment.
Regarding item number 47 of the combined list, my lord.
Not today. Not today, it will be taken.
Item number 65.
Should I appear for the response?
Petitioner, not today. After original side, members of the bar are under the impression that appellate side matters will not be taken up. Generally, it's not taken up.
Item number 66.
Today list has collapsed since Mr. Partho Ghosh is absent. He appears on behalf of ECL in all matters.
My lord,
Yes.
Mr. Subodhotto arguing this matter. In this time, Mr. Subodhotto engaging to the.
Yes.
My lord, in this matter, Mr. Subodhotto arguing this matter. In this time, Mr. Subodhotto engaging to the another board. I am paying for.
Not today.
Not this week.
Well, let me see.
Not this.
No, not this week. Not this week. Not today.
Great, my lord.
Yes.
Item number 67.
67, I appeal for the petition being laid by Mr. Bilwaran Bhattacharya due to the personal difficulty when he has left the court.
Who?
Mr. Bilwaran Bhattacharya.
Not today.
Next week,
No, I will not fix up any matter from combined list. I do not fix any matter. No. Sorry. Yes.
Not today.
Item number 68.
Lordships, I'm appearing on behalf of the respondent. The Lordships, I'm praying for not today.
Not today.
69.
69, I'm here for the High Court administration.
Yes. District Judge.
Lordship, on the last occasion, your Lordship directed me to serve a copy upon the private respondent.
You are representing petitioner.
I am for the petition.
Place your case.
This is the affidavit of service. Lordship, the petitioner before your Lordship was appointed as the head clerk of learned District Judge Nodia. And there was a notification for appointment of recruitment of appointment of from appointment of stenographer grade 3, that is at page 50. If your Lordship will kindly come to page 50.
Yes.
Yes. This is the notification.
What you are praying for?
Now, your Lordship, next page is the pro forma, which says certain documents were required to be produced at the time of interview, Lordship. Now, my main case is that those documents were never asked.
You participated in the
I
selection
participated,
process.
Lordship. Now, your Lordship, kindly see the next page, page 51.
Now, have you been selected?
I have not been selected.
Now, the select list has been prepared.
Yes.
Appointments have been
Yes,
given.
yes.
Then, what remains?
Because I had been
What are the then you have to demonstrate before this court that there are illegalities.
Yes, there are illegalities because
in initiating and concluding the selection
yes,
process.
that is the thing.
What are those illegalities? Tell me.
Illegalities is that on the day of when the inspection has to be made, candidates has to produce the documents which is at pro forma page 51. Admittedly, they have admitted those were not produced by all those were not checked by the appointing authority. Subsequently, on the basis of a meeting, they have taken the documents which is not permissible. as per the gazetted notification. That is at page.
This pro forma
21.
was required to be submitted at a time of
These documents has to be-
when it was required to be submitted.
Yes, Lordship, that is in the notification, Lordship.
Just a minute.
May I read the notification?
No, it's not required. Just a minute. In a separate sheet along with copies of documents to submit their applications as per pro forma given in separate sheet.
Yes.
So it is already there that as per pro forma you have
As
to
per
make an
pro forma,
application.
you have to submit it before 31st of August. On 31st of August, this was not given because it was not conducted on that day. I will place everything.
Yes, what you are submitting?
Yes. On 31st of August,
So what is your grievance? Why your candidature could not be appraised, could not be considered?
My grievance is that the candidate who has been given the appointment, she did not produce the required documents as per the pro forma. While I was having those documents, on a subsequent date, I gave a letter. See this
So
document.
you submitted your candidature in prescribed pro forma within time.
Within time.
But the candidate who has been selected could not submit these documents. That is your case.
This is my case, Lordship, but this was not checked. I categorically, by letter, I have stated that as per the pro forma, you have not checked the documents. So you need to check that. They accepted, yes, it was not checked. Now, on a subsequent date, the private respondents, they have admitted they were allowed to produce extra documents on the date of selection. That cannot be done because your Lordship will kindly see the rules. That is at page 47. That is regarding appointment of English stenographer.
But I'm just asking what he's submitting is possibly on record, my lord, because what he is submitting and there are serious allegation against him, I will show. But what he is
Yes,
saying,
I will place because when I asked for that, well, you have not taken the, you have not checked the documents. On the contrary, they have stated you have leaked out whatever the decision has been made. I will demonstrate that, Lordship. Your Lordship will kindly come to page 47.
You are for the state. Who is for the state? And respondent number 6.
I have served as per
Probably
your
respondent number
Lordship's
6 is the selected candidate.
Yes.
Is what is your instruction?
Madam, first of all, my lord, kindly see, madam, kindly see, everything will be clear. There are some confidential, my lord, documents, but kindly see, my lord, from paragraph 8. The said promotion committee held another meeting dated 11 December 24 and submitted their resolution dated 12 December 24, mentioning that in terms of the resolution dated 22/11/24, the said committee has conducted a skill test for appointment of one candidate among 6 applicants for the post of English stenographer grade 3. Now, my lord, these 6 candidates, the petitioner is one of them. Now, what happened thereafter? That my lord, on 30th November 24, wherefrom it appeared that out of 6 applicants, one applicant, namely Amit Ghosh, did not appear in the skills test. Accordingly, based on their overall performance in all 4 segments, the skill test mentioned herein above, the marks which has been allotted and the marks which they obtained. Sunil Sen, the petitioner, obtained 131. Then, my lord, second one 102. And my lord, the person who appointed Miss Deboshmita Sarkar obtained 135.
Yes.
Deboshmita Sarkar, she obtained 135 marks.
Petitioner stood second.
Second.
In skill test.
Skill test. Then what happened, my lord? Now, my lord, kindly see, it is fact that before publishing the result by the office of the undersigned, a letter dated 12 December 24 submitted by Mr. Sen, and he submitted a letter attached to the English department to the office of the district judge Nodia, praying for verification of the documents regarding skill test for promotion of English stenographer grade 3, as no such documents of the candidate have been verified during skill test on 30th November 24, what my learned friend is submitting. But it appears from the point number 5 and 6 of the resolution dated 4/2/2025 of the promotion committee of this judgeship that all requisite documents were verified prior to appearing in the skill test by Dad and Serestadar and Najir, as they were verbally directed by the committee to do so. All the candidates appeared in the skill test. Therefore, it stands clear the requisite documents of all the candidates were duly verified. This next one is very vital. It is pertinent to note here that Sri Sen, being an assistant clerk attached to the English department, was engaged to deal with the confidential file regarding the promotional process. As the recommendation in form of resolution dated 11/12/24 was communicated to the office of the undersigned received on 12/12/24, it seems suspicious to the undersigned to have received such a letter as mentioned above from one of the candidates, namely Sunil Sen. Now, how can he get that document? We are also confused. Now, namely Mr. Sen, on the same date, immediately after sending the resolution of the committee to the office of the undersigned by virtue of his access to the said official document and by virtue of his unfettered access to the secret file of this office in all the matters, specifically when he is an interested party in the promotion process for his engagement to deal with such confidential file. Then, my lord, having regard to do so, maintain official secrecy, Sri Sen was asked to submit written explanation for such kind of act done by him of the office of the undersigned as per the provisions of Official Secret Act 1923, coupled with relevant rules. Now, my lord, he submitted the explanation. All documents are here. Now, my lord, what my learned friend is saying, that the document has not been verified, it is not correct. All the documents has been verified, and after verifying the same, my lord, this particular lady, my lord,
Private 6 was selected.
Some more documents were allowed to be submitted.
Absolutely not.
Yes, that is their reply to my RTI, page 63. Kindly come. Your Lordship will kindly come. Page 63.7. Whether any candidate appeared in the skill test held.
Skill test was the only test which was held for
that was the only
preparation.
test. Yes.
Absolutely.
Now, if the skill test you were not found to be the first candidate, how the verification or additional document verification will change the fate of the selection process.
Lordship, whatever the documents
because the speed was tested.
Yes.
in the skill test.
No, these were the criteria.
But kindly see,
Shorthand speed and the typing speed.
criteria is mentioned,
Whether
madam,
any
page 3.
Yes, yes.
If your lordship will kindly come to page 60.
So now the verification of document, how it will change the fate of the skill test or the result of the
Because those documents have to be
how
produced.
how it is relevant today.
Yes,
because
because
the
those
skill-
documents I should have possessed at the time of skill test, page 63. Whether any
Yes.
candidate appeared in the skill test held in view of notification dated such and such, submitted any further extra documents during the re-verification documents held, which were not submitted by 31st. Or prior
What
to
are the
skill-
documents which were required to be submitted? Come to page 51.
Yes, 51, whether any knowledge of computer operation, whether any
Now he
knowledge
has
of
been
shorthand
transferred in
and
petitioner
typing.
log, that's why it is writ petition. We have secretly stolen those documents and
No,
supplied
we
to the
have
party.
not, lordship.
That's why
We
we have
have not.
subsequent
We have
transferred.
given our reply. What was our, kindly come to page, my letter dated.
Now, I am asking you that apart from personal information, that is name, father's name, present date of birth, only two
That is the main-
conditions or two informations
Yes,
are
yes.
relevant. Whether any knowledge in computer operation and whether any knowledge in shorthand
I
and
should have
typing.
possessed that before the skill test, lordship.
Shorthand and typing.
Yes, that was the.
Now,
gazetted
in the
notification.
typing test and shorthand test, you scored lower than the respondent number 6.
That is what they are saying.
Now, is it your case that on the date of on the prescribed date or on the cutoff date, respondent number 6 did not have the requisite qualification?
That is my case.
That is your case.
That is
Where you have
stated.
stated in the writ
Yes.
petition. Then how she performed better than you in the skill test?
Let them file their affidavit in.
No, I am asking you. Why affidavit? It's a performance based test.
Yes. Because-
Accuracy and speed. Now, if accuracy and speed is
But
in terms of accuracy and speed, respondent number 6 performed better than you, then can it be presumed that she did not have requisite qualification relating to knowledge in computer and
that is the criteria, lordship.
and knowledge of shorthand and typing?
That is the criteria for applying. That is at page 47.
Where you have made out the case that petitioner respondent number 6 did not have the requisite qualification?
They have not taken it.
Please show me from the writ petition that you have made out such case. এই শিবু এর কাউকে ডাকো তো এফিডেভিট সার্ভিসটা পড়ে গেছে তুলে দেবে। Show me from the writ petition you have made out a
Page
case.
6, paragraph 12. Your petitioner stated that the petition.
কত বললে?
No, I am asking you a different thing.
Page 8,
Where you have
paragraph
stated.
80. Page 8, paragraph 80.
ওই দেখো। এটা কিভাবে verify করবো? 18 is his knowledge. Kindly let him produce.
And your lordship will kindly see page 47, qualification for direct recruitment. That
This is your knowledge, to your knowledge.
Let him produce.
On what basis?
No, information, if I have an information from the record,
So come
I
to
could have
the
used it.
supporting affidavit, accompanying affidavit. 1 to 26 knowledge and 41. How can it be? Yes.
I have not said it is on record.
When you did come to know that the respondent 6 did not have the requisite qualification
Dr.
in
immediately-
terms of knowledge in computer and typing skill and shortened skill.
Your Lordship, that RTI replies because subsequently documents were produced.
Document verification is
the
different thing. From
Pre-quali-
where you
pre-quali-
came to
pre-qualified Lordship.
know.
But my case is that if your Lordship will kindly come to page 47 once. Right hand column. What are the qualifications required? Must have passed typing test or have such knowledge or qualification in computer operation and in shorthand as may be specified by the High Court at Calcutta from time to time. Now at page 51, the pro forma says 2 documents has to be produced at the time of skill test. No other documents are required to be produced. Then what on earth were the documents which were produced subsequently, which was their reply to the RTI? What documents? Let them disclose why these documents were allowed. Page 63. The resolution cannot allow it because the gazette notification, as per the rules, you have to produce it before the skill test. This is the whole illegality.
Now, at the time of submitting documents, in terms of the notification dated 20th August 2024, the last date was 31st of August 2024. What is the procedure followed? The documents were
with them, and that
documents were accepted and verified,
absolutely,
and any acknowledgement was granted.
kindly see paragraph 9 of my report.
No, any acknowledgement was granted.
Yes, yes. It is his allegation. Now, on the basis of
that documents are verified on so and so date.
Absolutely.
So
But-
file a short affidavit. Issue.
My lord, I appear.
Disclosing that when respondent number 6 submitted documents.
And moreover, all the candidates.
The respondent number 6, my lord. My lord, since 1st February 2021, I have been working in the post of lower division
Yes, yes.
clerk. My lord, the
Matter is heard in presence of the learned advocate representing the petitioner. Stop.
Only
Next
one.
paragraph.
I will definitely file. Let him also file. It is his knowledge.
Nothing is required. You file an affidavit. Short affidavit disclosing when these documents were submitted by the petitioner before the authority in
by the
terms of
respondent 6.
20th August 2024. Enclosing acknowledgement.
And Lordship, extra documents which were
কি বলছিলাম, hard in presence of the learned advocates representing the parties. Stop. Next paragraph. Matter relates to appointment in the post of English stenographer within bracket grade 3 close bracket under judgeship of Nodia. যেটা small করবে, হ্যাঁ, সবাই under judgeship of Nodia. Stop. According to the next paragraph, according to the petitioner, in terms of recruitment notification dated 20th August 2024, the selected candidate, the respondent number 6 being selected candidate, submitted documents in the prescribed pro forma after the cutoff date, after the last date, that is 31st August 2024. Next paragraph. 31st August 2024. Stop. Stop. Next paragraph. Last date was 31st August 24. Next paragraph. Respondent number 4 is directed to file a short affidavit disclosing when respondent number 6 submitted documents in the prescribed pro forma and in the report, if any acknowledgement was made by the respondent authority while accepting documents of respondent number 6, same shall also be disclosed. Stop. Let such affidavit, let such report be filed by 10 days from date.
Affidavit.
Stop. Stop. Let such affidavit be filed by 10 days from date. Hearing of this matter stands adjourned till or let the matter appear under the same heading in the monthly combined list of February 2026.
Mark sheet and other documents that already been with me, my lord.
Very well, file an affidavit.
Only thing, my lord,
সব
district
জায়গায়
judge,
affidavit করে দেবে, report করবে না।
district judge, or my lord, the selection committee of any of that additional district judge or district judge.
আচ্ছা। Now let the respondent number 4 file an affidavit.